ರಿಮೈಂಡರ್ ಅಂತ ಮಾಡಿದೆ. ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್
ಸರ್. ಕೋರ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ನಾನು ಡಿ.ಆರ್. ರಾಜಶೇಖರಪ್ಪ ಸರ್.
ಸರ್ ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅಡ್ಮಿಷನ್ ಇದೆ ಸರ್. ಒಂದು ವಾರ ಕೊಟ್ಟಿದ್ರೆ ಒಳ್ಳೆಯದು ಸರ್.
ಸರ್ ಅಡ್ಜರ್ನ್ ಮಾಡಿರ್ತೀವಿ, ಬಟ್ ಡೇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಂದ ಸಾಹೇಬ್ರು ಇರಲ್ಲ ಅಲ್ವಾ, ಡೇಟ್ ಸಾಹೇಬ್ರು ಬಂದೇ ಕೊಡ್ತಾರೆ ಸರ್. ನಾನು ನೋಟ್ ಮಾಡ್ಕೊಂಡಿರ್ತೀನಿ.
ಓಕೆ
ಸರ್. ಲಿಸ್ಟ್ 2 ಮ್ಯಾಟರ್ ನಂಬರ್ 5 ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಬೇಕಿತ್ತು ಸರ್. ಅದರ್ ಸೈಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀವಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ತಾವ್ ಯಾರಿಗೆ ಅಪೇರ್ ಆಗ್ತೀರಾ?
ಕೋರ್ಟ್ ಆಫೀಸರ್
ನಾವು ಪೆಟಿಷನರ್ ಗೆ ಅಪೇರ್ ಆಗ್ತೀವಿ.
ಲಿಸ್ಟ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 14.
ಸರ್ ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ ಸರ್.
ಸರ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅದರ ಅಪೆಲೆಂಟ್ ಗೆ ಅಡ್ಜರ್ನ್ ಮಾಡಬೇಡ್ರಿ ಅದನ್ನ ದಯವಿಟ್ಟು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 14 ಇನ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅಲ್ಲಿ ಎಮರ್ಜೆನ್ಸಿ ಇದೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸೀರಿಯಲ್ ನಂಬರ್ 11 ನೋಟ್ ಮಾಡ್ಕೊಂಡು ಮಾಡಬಾರ್ದು ಅಂತ ದಯವಿಟ್ಟು.
ಮತ್ತೆ ಎಲ್ಲಿದೆ ಅದು?
ಆಯ್ತು ಸರ್, ಆಯ್ತು.
ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಸರ್.
ಡೇಟ್ ಯಾರಿಗೆ ಅಪೇರ್ ಆಗ್ತೀರಾ ಮೇಡಮ್ ತಾವು?
ಅಪೆಲೆಂಟ್ ಗೆ. ಅದ್ರ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆ ಸರ್.
ಆಯ್ತು ಮೇಡಮ್.
ಗೊತ್ತಾಗತ್ತ ಅದು?
ನಮ್ದು ಧಾರವಾಡ ಬೆಂಚ್ ಯಾವಾಗ ಕರೀತಾರೆ?
ಆಯ್ತು ಸರ್, ಆಯ್ತು.
ಕೇಳ್ರಿ ಅಂತ ಧಾರವಾಡ ಬೆಂಚ್ ಯಾವಾಗ ಅಂತ ಹೇಳಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ
ಸರ್. ಧಾರವಾಡ ಬೆಂಚ್
ಆಯ್ತು ಮೇಡಮ್, ಆಯ್ತು ಆಯ್ತು, ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 14.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಇವಾಗ ಅವರು ಮಾಡ್ಬಿಟ್ಟೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಏನ್ ಮಾಡ್ಬೇಕು
ಸರ್? ಧಾರವಾಡ ಬೆಂಚ್ ಮಾಡ್ರಿ ತಗೊಂತಾರಲ್ಲ 10:30ಗೆ
ಬರ್ತಾ ಇತ್ತಲ್ಲ
ನೀವು ಮಾಡ್ರಿ
ಸರ್. ಧಾರವಾಡ ಬೆಂಚ್ ಮಾಡ್ರಿ ತಗೊಂತಾರಲ್ಲ
ಸರ್. ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ ಹೇಳ್ತಾರೆ ಸರ್ ಅದು.
ಓಕೆ,
ನೀವು ಕೇಳ್ರಿ ಅಂತ ಹೇಳ್ರಿ
ಸರ್. ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಯಾರಿಗಾನ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಇದ್ರೆ ಹೇಳಿ ಸರ್.
ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಲಿಸ್ಟ್ ನಂಬರ್ 1.
ಅದೆಲ್ಲ ಸಾಹೇಬ್ರು ಟೈಮ್ ಕೊಡ್ತಾರೆ ಸರ್.
ಸರಿ ಸರಿ, ನಾನೇ ಬರ್ತೀನಿ, ಇರ್ತೀನಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವರೇ
ಸರ್,
ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಾನು ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ ಕೊಡಿ ಅಂತ ಕೇಳಿ ಅಂತ ಹೇಳಿದ್ರಿ.
ಅಲ್ಲಲ್ಲ, ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ. ಡೇಟ್ ಬಂದ್ಮೇಲೆ ಕೊಡ್ತಾರೆ ಸರ್, ಯಾಕಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇರಲ್ಲ ಸಾಹೇಬ್ರು.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಕೊಡಿ, ಯಾರಿ ಮುಂದಾದ್ರೂ ಪರವಾಗಿಲ್ಲ. ಡೇಟ್ ಏನು ಕೇಳಲಿಲ್ಲ ನಾನು, ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟಂಗೆ ನನ್ಗೆ ಕೊಡಿ. ಇಲ್ಲ ಅವ್ರು ಬಂದ್ಮೇಲೆ ಮೂವ್ ಮಾಡ್ಕೊಡ್ತೀನಿ, ನೋ ಪ್ರಾಬ್ಲಮ್.
ಇಟ್ಕೊಳ್ಳೋದೈತೆ ಮೊಬೈಲ್ ಲ್ಯಾಪ್ಟಾಪ್ ಮತ್ತೆ
ಇಲ್ಲಿ ಇದನ್ನ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ಟು. ಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್?
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಎಸ್ ಸರ್. ಈಗ ಲೈವ್ ಇದೆ ಅಲ್ಲ? ಇಲ್ಲಿ ಮೇಲೆ ಲೈವ್ ಆನ್ ಇದೆ.
ನಾನು ಅಲ್ಲಿ ಇತ್ತಲ್ಲ ಕ್ಲಿಕ್ ಮಾಡಿದೆ, ಮತ್ತೆ 5 ನಿಮಿಷ
ಆಕ್ಚುಲಿ ಏನಾಗುತ್ತೆ, ಇದು ಏನ್ ಬ್ರೌಸರ್ ಅಲ್ಲಿ ಬಂದಿರುತ್ತಲ್ಲ ಸರ್, ಬ್ರೌಸರ್ ಅನ್ನ ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಕು. ಅದ್ ಬ್ರೌಸರ್ ಕೆಳಗಡೆ ಇತ್ತಲ್ಲ, ಅವಾಗ 2 ವಾಯ್ಸ್ ಕೇಳಿಸ್ತದೆ.
ನಾನು ಮಾತಾಡಿ 2 ನಿಮಿಷ ಮತ್ತೆ ರಿಪೀಟ್ ಆಗ್ತದೆ. ಸರ್ ಹೇಳಿ ಸರ್. ಈಗ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಈಗ ಸರ್, ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಯಾರಿಗಾನ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಬೇಕಾ?
ನಾನು ಹೇಳ್ಬೋದು ಸರ್. ಡಿ.ಆರ್. ರಾಜಶೇಖರಪ್ಪ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ ಸರ್. ಸರ್ ನೋಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ ನಿಮ್ದು.
ಓಕೆ, ಒಳ್ಳೇದು, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ಯಾರಿಗಾನ ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಬೇಕಾ? 18 ಅದು ಇದೆ, ಈಗ 19
ಕೊಡಿ ಮೆಮೊ.
ಕೊಡ್ಬೋದು ಸರ್.
ಸರ್ ಬರ್ತೇನೆ 100 ಅಲ್ಲಿ
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ Sir, court officer.
ನಮಸ್ಕಾರ.
ನಮಸ್ಕಾರ. ತಾವೆಲ್ರಿ ಇಲ್ಲಿ ನಮ್ಮ ದೂರದರ್ಶನ ಬಂದಿದ್ದೀರಿ? ಪೇಜ್ ನಂಬರ್ನ ಹೋಗಲ್ಲ.
ಸರ್ ಅಡ್ಮಿಷನ್ ಮ್ಯಾಟರ್ಸ್ ಯಾರಿಗಾನ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಬೇಕಾ ಸರ್?
ಸೀರಿಯಲ್ ನಂಬರ್ 32 ಕೊಟ್ಟಮ್ಮ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 32 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬೇಕಲ್ಲ
ಸರ್? ಸಾಹೇಬ್ರ ಬಂದ್ಮೇಲೆ ಮೆನ್ಷನ್ ಮಾಡಿ, ಲಾಸ್ಟ್ ವೀಕ್ ಇದ್ ಮಾಡಿದ್ರಲ್ವಾ, ಸಾಹೇಬ್ರ ಬಂದ್ಮೇಲೆ ಹೇಳಿ.
ಹೌದಾ? ಓಕೆ ಓಕೆ.
ಕೋರ್ಟ್ ಅಲ್ಲಿ 18 ಅಲ್ವಾ?
ಹೌದು ಸರ್, 18 ಇಲ್ಲಿ 19 ಇದು.
ಸರ್ ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಫಸ್ಟ್ ಕರಿತೀರಿ ಅಥವಾ ಬೆಂಗಳೂರು?
ಸರ್ ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ ಹೇಳ್ತಾರೆ. ಸಾಹೇಬ್ರು
ಸೀರಿಯಲ್ ಕೋರ್ಟ್ ನಂಬರ್ 19 ಬೋರ್ಡ್ 18 ಬೋರ್ಡ್
20
ಇವತ್ತಿಂದ 20
ಡೇಟಾ ಓದ್ಲ
ಅಲ್ವಾ ಸರ್?
ನಾನು ಮುಗಿಸ್ ಬರೋಕ್ಲೆ ಆ ರೇಟ್ ತಗೊಂಡ್ ಹೋಗ್ ನೋಡು. ಸುಷ್ಮಾ
ಹೌದಾ ಕರೆಕ್ಟ್ ಟೈಮ್ಗೆ ಹೋಗ್ಯಾರ ಯಾವ
Serial number 3 and 8 in list number 2 are adjourned. 3 and 8.
Interim order can be extended for 8 months. Serial number 8.
We done.
Obliged.
But serial number.
List number 1. Serial number 1 to 21. 3 weeks
Please.
time is granted to do the needful.
Please.
Don't have to wait for me.
31 my lord.
The serial number,
They will post it as and when it is convenient. Unless it's extremely urgent, you don't have to move.
the serial number
31.
1 minute, 1 minute. I'll finish all of them and complete.
Yes.
My lord, serial number 31, my lord.
Just a minute.
My lord, serial number 31, my lord.
Please wait 1 minute. 98. ಇದು level. ಕೊಡು.
Serial number 31, my lord. Move ಮಾಡಿದ್ವಿ. Day after tomorrow, today has to not
Next week. Next week.
Serial number 31, my lord.
Next week.
Serial
31
number-
next week.
Much obliged.
serial number 32, my lord.
Ah.
But now I've taken in the last occasion also I've taken time. But some function is there, some inability, my lord, I can do. Well, you let me kindly put it on one, my lord, first day. 1ನೇ ತಾರೀಕು.
Next week.
Serial number 29, my lords.
Yes.
Next week, my lords.
Next week.
My lords, serial number 5 in list number 2, my lords.
Serial number?
Serial number
Serial number
5 in list
20.
2, my lords. Kindly have it next week, my lords. We have informed the other side.
5 ಯಾರು? Sadashivappa.
Sadashivappa, we have informed Sadashivappa.
Next week.
Serial number 28, my lords, second list. I am for the caveat. My caveat is written. I have written I have to furnish the power of attorney, my lord. I have written the parties. I have not yet obtained. However, the interim order is already granted to the other side last week.
28,
Yes, my lord. I am for the respondent caveat. My caveat is written.
Interim order please.
Interim order already granted last week.
All right.
Your lordship, your lordship, serial number 17 in list number 2, your lordship. I'm for the respondent.
Yes.
Pray for time to file fresh wakalat, your lordship. It's still showing my senior's name who is now designated.
Inform the other side.
I'll inform the other side, your lordship.
If they have any objection, what do you do?
I'll wait till the matter reaches your lordship otherwise.
Very well.
Obliged.
Serial number 13, my lord. Number 2.
Yes.
For appellate.
2 weeks.
Number 2 for petition.
My lord, submission regarding forward bench, my lords.
ಫಾರ್ವರ್ಡ್ ಬೆಂಚ್ ಇವತ್ತು ಮಧ್ಯಾಹ್ನನೂ ಇದಿದೆ, ಬೆಂಚ್ ಇದೆ ನಂಗೆ.
My lord, serial number 6, my lords.
Yes.
My lord, I appear for respond number 2, my lords. The government has sought for clarification, my lords. My lords may kindly take up the matter in the first week of March, my lords.
But either way, I'm coming to Dharwad. I'll take up all these matters there.
Please, all these matters,
Please,
it may be taken up in Dharwad.
Please.
Oblige. Oblige.
Next week.
Oblige, sir, oblige.
Lordship, one submission.
All the Dharwad bench matters more next week.
Yes.
Dharwad bench, serial number 1, that is review petition number first matter. That may be taken. I don't know.
Next week, ಅಲ್ಲೇ ಧಾರವಾಡಗೆ ಹೋಗ್ತೀನಲ್ಲ, ಅಲ್ಲೇ I take it up there only.
ಅಲ್ಲ, ಇದು ಸ್ವಲ್ಪ there is some urgency. Difficulty is not confirmation of sale will be done, Lord, on.
Where's Mr. Hiremat?
In fact, I just wanted to let's say, verify as to why representation cannot be considered. Such a representation is not given to the bank only, Millard. Even the writ petition papers which was served.
Annexure C to the writ petition itself speaks.
Now, Millard, kindly, Millard, see their contract also, Millard. They buy 2 months time to clear the entire dues. They wait for almost one month thereafter. Now, thereafter, a review petition is filed only on the ground that the representation ought to be considered.
Why don't you consider it within a week and close it, Mr. Hiremat?
That's all, Lord. That is all.
Why do you want to unnecessarily sit on technicalities? I'll call this next Monday. By that time, you decided I'll dismiss the reviewers who have become infructuous.
Yes.
Please.
But in the meantime, Lord, one more submission. But till then, my lord, let the sale not to be, confirmed.
Can you wait for a week, Mr. Hiramat?
Please,
But we have sold some property and we have made arrangements. We will once for all get rid of.
They're gracious to say they won't do anything for a week. Again, model on the one vara. I'll take their word.
That's my record, my lord, saying that, my lord.
No, I'll trust him because I trusted you for 2 months.
I also trust.
No, next week.
Not a sale is confirmed, that would be the problem. Yes.
Next week, let us see.
I would. Please, my lord.
Lordship, all the Harvard matters next week, Lordship.
Yes, next week.
Please.
By affirming reasons addressed by
next week ಅಂದ್ರೆ next ಸೋಮವಾರ ಬರಬೇಕಲ್ಲ.
Now the merits of the case, government court has no conventional requirement. Has rejected the appeal on technicalities. There is no satisfactory reasons assigned by the appellate petition. The issue before the trial court was the suit filed by the granddaughter of petitioner seeking partition. A parallel suit was also filed by the son of
that is on the merits.
Yes, Lord. When the trial court has accepted a part of the document, the compromise arrived in the parallel to grant partition for the respondent number 1. In respect of which I don't have any grievance. But while coming to the determination of the rights of the petitioner, it says, no, it has accepted a portion of the compromise petition and it has declined to accept it as a part of my rights. So that is the proposed ground which was addressed before the lower appellate court. Of course, delay is always a factor that a party should not speak over the rights. Not looking into the background of the case and the status of the lady. My grievance is that the lower appellate court at least should have looked into the merits of the case.
There's a delay. We tell them that you should not look into the merits. Decide only on the question of delay. If you're now asking us to look into the question of merits of the case, when deciding the delay application, then both of them are.
Identical circumstances, a coordinate bench of disarmament court says even 500 days
You should show me an error in my order which has vitiated the order. I only confirmed the order of the appellate court which dismissed your appeal on the ground of delay.
Now what happened, Lord? The entitlement of the respondent number 1 plaintiff, what she got beyond her entitlement.
You did heard, no grounds, rejected. Another consent ತರ ಮಾಡಿದೆ ಅಲ್ವಾ? Both of you agreed for this. Both of you agreed for this course of action. I told them that I'll do this. Both of you agreed. Therefore, this order came to be passed.
The 1948 said the width of the property was sold to me was 60/40. Court commissioner was appointed by this honorable court. Notes that the house which I am occupying measures 50 feet and then also notes a 4 feet wide space on the western side. Now what happens is since this 4 feet wide space has been thrown open to the common use of both the parties. What was conveyed to me in the year 1948 as tax reduced. That is
That is what I said. I will do this so that both of you won't fight. This passage between the two houses in the photograph that you produced.
It's not a passage. The commissioner has also noted it is a vacant space. It's not a passage.
The photograph that you showed me clearly indicated It is a passage. If you would not have left 2 feet next to your house. Yes, on that basis only this order was. ಹಂಗೆ ಎಷ್ಟಿದ್ಯೋ ಹಂಗೆ ಎತ್ಕೊಂಡಿದ್ದು ಅಷ್ಟೇ ಹೇಳಿದ್ ನಾನು. ನೀನು ಇದ್ ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ, ಹೆಂಗಿದ್ಯೋ ಇಷ್ಟು ವರ್ಷ ಹಂಗೆ ಬಂದ್ಬಿಡ್ತು. Don't try to do anything now, accept that position and move on. Don't fight for 2 feet ಅಂತಾನೆ ನಿಮ್ಗೆ ಹೇಳಿದ್ದೆ.
4 feet by 192 feet. ಕಮ್ಮಿ ಆಗಿದ್ರೆ what was conveyed to me 74 years back.
That is not Brigade Road or some other road for you to fight.
Rural folk, my lord, it is a very clear, it's a partial for the rural folk. For us, my lord, city my lord, but my lord, 4 feet by 192 feet, 4 feet by 50 feet.
Then according to you, I shall simply dismiss the appeal. I thought because you agreed, I dismissed the appeal, and notwithstanding the dismissal, I had made this observation so that they will not, both of you will not claim independent right. No, if you are going to say, then I just confirm the order to the extent of dismissal and not talk about the other observation that I made.
My lord, it will have to be reheard, my lord, because 70.
I have dismissed this on merits. Your remedy is elsewhere.
There is an error.
Unless you show me.
I respectfully point out there is an error. Because 74 years back, what was the measurement which was conveyed to me cannot be reduced by virtue of a judicial order. That is why submission. But diminishes, my lord, what was conveyed to me 74 years back.
This was told to both of you. Both of you agreed that let us not fight. ನಿಮ್ದು already ಅವ್ರದ್ದು already ಒಂದು ಜಾಗ ಕಾಮನ್ ಆಗಿದೆ, ಅದ್ರಲ್ಲಿ ಉಳ್ಕೊಳ್ಳಿ ಬಿಡಿ, ಕಿತ್ತಾಡೋದು ಬೇಡ ಅಂತ ನೀವು ಹೇಳಾದ್ಮೇಲೆ ಈ ಆರ್ಡರ್ ಮಾಡಿ. Dismissing the appeal, I made it clear that none of you will have an independent right for this particular 4 feet.
Now what has happened is, my lord, some alterations have already been taken place.
Make an application, use sue for execution or for contempt if he has violated this order. Because I had clearly said that they both of you will not cause any impediment for the use of this particular space. If he has committed an impediment, I have given you liberty.
My lord, what will happen to my entitlement which was conveyed 74 years back, my lord?
No grounds, rejected. Yes, Ramesh. What do you want to do? You want to argue or? It's up to you. No, if he wants NOC, he wants NOC. You want to argue or you want to adjourn? Let them engage somebody else. Not counsel for the appellant. That this client wishes to engage another counsel. That will matter. Let the matter be listed. Yaki, you don't want to argue. Why do you want to argue? All after 2 weeks.
Serial number 6, my lord.
Yes.
I'm for the appellants, my lord. It is a suit per partition, my lord. It is the appeal by the plaintiffs. My lord, in the trial court, the suit was decreed in my favor in respect of the partition, my lord. In the appellate court, my lord, the court has.
What is related to the respondents?
Respondents are children of respondent number 4.
Genealogy is
in page number. Yes, my lord.
You are the daughters of Ramchandra.
Children of Ramchandrappa.
That is the 4th son.
Yes, my lord.
Then defendants Venkateshappa.
Venkateshappa, my uncle.
Is the first son.
First son. Srinivasappa died. Rajamma came into record.
Aryan Swami is the 3rd son.
Yes, ma'am.
Who's D4?
My lord,
Who's D4 Ramchandrappa? Your father.
D4 is our father.
D5
No, my lord,
Shankarappa.
Shankarappa is another
Sixth son.
sixth son.
Vinodamma is the aunt.
Yes, my lord.
You filed the suit against your father when he was alive.
Against all the defendants, claiming that the share of my father, the contention of respond number one, defend number one was, my lord, my father executed a cash release deed in favor of him.
In favor of?
In favor of respond number one.
Defendant
defendant number one.
When was it executed?
It was executed on 10/5/2005.
10/5/2005.
Yes.
Registered?
Well, it is registered, but there is no mention of about any survey number. Survey numbers are not mentioned in it.
And the property belongs to whom?
It is undivided property. It is ancestral property. It was not at all divided, but the RTC was in the name of first dependent. Taking the advantage of that RTC, my lord, the document was registered.
In the ancestral, in the relinquishment deed, there is a receipt that it is ancestral property.
My lord, it is mentioned ಹಿಂದೂ ಕುಟುಂಬದಲ್ಲಿ ಅಣ್ಣ ತಮ್ಮಂದರಾಗಿ ಸಂಸಾರ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿರೋದು ಸರಿ ಅಷ್ಟೇ.
Why did the appellate court reverse the decree then?
My lord, the appellate court is opined in page number 24, ink page number 24. It is seen that exhibit D1, that is relinquished deed, has been executed by the father of the plaintiffs, even if it is considered that the suit schedule properties were the ancestral properties, and the plaintiff has not signed the said document. The plaintiffs should have sought for cancellation of release deed. Since the said document has been executed by the father of the defendant number 4, therefore, the present suit for partition and separation of separate position without seeking any such relief, cancellation of release deed cannot be maintainable.
The appellate court was justified in dismissing the suit for partition when only on the ground that the plaintiffs had not sought for a cancellation of the release deed executed by their father, bracketed defend number 4.
Admitted, my lord?
Yes.
Number 7, my lord.
Yes.
My lord, I appeal for the appellant. My lord, there are 3 suits, my lord. One suit, my lord, is filed by, my lord, the respondents number 1 and 2, my lord, in RSA 752, my lord. My lord, may I kindly take RSA 752.
752. You are for the plaintiff.
Yes, in 2 suits, my lord, I am for the plaintiff. I sought for possession of the property. In 1 suit, my lord, my brothers, they filed suit for partition, my lord. There are 3 suits together, my lord.
You are Gopala or Chinnaswamy.
Chinnaswamy.
Who are you?
I am, my lord, the elder brother, my lord, of the family, and elder brother of, my lord, the first and second respondents. Initially, my lord,
you are the defendant in OS 64/2008.
Yes, my lord.
OS 64/2008 is for what?
It is for partition. Lord, the proposal.
There is no dispute regarding the relationship.
No difference, no. No.
The plaintiffs are your brothers.
Yes, ma'am. Plaintiffs are my brothers.
And your suit was for possession.
Possession, my lord, from the brothers, my lord. Only in respect
two
of, my lord,
suits?
the house property.
Why two suits?
Two brothers, my lord. Two different brothers, my lord. They are different possession. That's why two suits, my lord. A house, my lord, was divided into three parts, and they were given permissive possession, my lord, by me. The permission was revoked by me, and then a suit for possession was filed.
Was the house allotted to them, to you, according to you?
No, house was not allotted to them. They had a separate house, my lord, in survey number 86. Due to, my lord, heavy rain and, my lord, overflow of canal water, my lord, their house got destroyed. And then, my lord, being a brother, my lord, I had permitted them, my lord, to continue in possession of my property.
Is it your case that you had purchased this house?
No. This was, my lord, in my unauthorized possession. After the partition of 1975, my lord, there was a partition between the brothers.
Date,
my lord. It is a oral partition. There is no date, my lord. Everybody have accepted it, my lord. 1975, there was a partition. And thereafter, my lord, I made an application.
According to you, you say in the oral partition, the property was given to you.
No, it is not given to me. Oral partition, my lord, the survey number, my lord, 25 of Arkere village was given to me. About 1 acre 11 guntas. That I sold and purchased a different property. This suit federal property was in my unauthorized occupation. This was sought to be regularized by me individually, and the government not regularizes my possession, not in the year 1978.
This is a question of two houses. Where is a question of regularizing your?
Not only house, my lord, it contains, my lord, about 1 acre 20 guntas of land also.
No, what is your suit schedule?
Suit, my lord, for in my suit, my lord, it is only the house property. They seek for partition of, my lord, the entire property. It's 1 acre 20 guntas of land.
Schedule rates two portion of residential house belonging to plaintiff 1 and 2. One portion belongs to defendant number 1. All the three residential houses are in the same roofing and situated in survey number 243 of Arkere village, measuring 1 acre 20 guntas.
Yes, ma'am.
So you're only seeking for the residential houses.
Yes, possession of residential houses. The rest of the property, not I'm in possession. They claim partition not in that property.
In the rest of the house, where is their schedule?
Schedule, not it is not.
Our suit, yeah, the OS number. RSA?
OS number 332, my lord, and 333, my lord.
ಅಲ್ಲ ನೀವ್ ಹಾಕಿರೋದು OS64 ಅಲ್ಲಿ ಏನು what is the schedule? They are seeking for partition of 1 acre 20 guntas or?
They are seeking partition of 1 acre 20 guntas. They seek to allot 20 guntas each.
No. RSA 763 is filed by Chinnaswamy against the judgment passed in OS
333, my lord.
333 is also house.
Is for yes, my lord. That is only with respect to house.
No, I have a doubt. In your suit, did you seek for 1 acre 20 guntas or just for the house?
Just for the house, my lord. They were given permission of, my lord, to be in possession only in respect of, my lord, portions of the house, my lord, where all three brothers together resided, my lord.
So they are also not seeking for partition of the entire house, or are they seeking?
They are seeking for entire, my lord, landed property, my lord, 1 acre 20 guntas.
What did the trial court do?
Trial court, my lord, held, my lord, in my favor. Trial court, my lord, accepted the contention that there was a partition in the year 1975 and the regularized lands, my lord, in the year 1978 are the self-acquired properties, my lord, of the first appellant herein. And, my lord, that it belongs to joint, my lord, the small joint family, my lord, of the appellant herein, because not the erstwhile joint.
Where did they admit the 75 partition in the written statement?
No, they have not accepted, my lord. They have taken a contention that only two brothers, my lord, were given separate partition, my lord, in the year 1975. And they contend, my lord, that the first appellant and the respondent number 1 and 2 resided together, my lord, from 1975 to up to, my lord, 2001, they claim.
So no, according to you, there is a partition year 75, which included this particular property. Is that your case?
No. This suit property was not at all included, my lord. This was in unauthorized occupation of, my lord, the first appellant. After the partition, It was regularized
When you-
being my name.
When you were joined, you were an unauthorized portion of one particular property. Is that
No,
your
no.
case?
After my lord, I became lord independent by virtue of partition of 1975.
Let us see your plea.
In OS not 64, my lord.
First,
64, my lord. OS 333 and 332, my lord.
Petition stands.
the appellate court has found that you are not in separate position. You are in joint position.
Yes, it my lord, reverses the findings and says, my lord, we all three, my lord, are entitled for equal partition.
What is the reasoning paragraph?
Paragraph, my lord. Paragraph 32 onwards, my lord. May I, my lord?
Yes.
On analysis of the entire material placed before the court, there is no document on record to prove the severance of joint status among the family members. On the contrary, both the parties have relied upon the revenue documents to substantiate their respective claims. So the moot question that requires to be considered is whether the revenue records are sufficient to draw inference of partition by metes and bounds. Hence, at this juncture, this court has relied upon the ratio laid down by the Honorable High Court in ILR number so and so, which held as follows. Hindu law partition suit, plaintiff suit for partition and separate possession decree. Appellant appealed against. The suit was dismissed. Plaintiff's regular second appeal. Appreciation of oral and documentary evidence by the trial court had been disbelieved by the lower appellate court. The lower appellate court has placed its reliance on the entries in the RTC to show that the parties have resided separately, and they have also made arrangements for the enjoyment of the land separately. Whether such a fact would draw inference of partition by metes and bounds. Held, mere fact that the parties have been in separate possession and enjoyment of the properties would not by itself lead to inference of partition by metes and bounds. The entries in the records of rights separately in the name of family members would not prove the prior partition. The first appellate court was not justified in setting aside the judgment and decree passed by the trial court, which passed the judgment and decree after the appreciation of oral and documentary evidence on record. The said
Did you produce your application seeking for unauthorized
yes,
regulation of your unauthorized occupation?
Yes, it is produced, no.
Exhibit?
It is in my individual name, not in the joint family.
Exhibit. Where is your application? Because the appellate court finds fault with you for not producing the sale deed under which you sold one property.
Yes,
in order to indicate whether there's a partition at all. Where is your application?
Exhibit P17, bro. P1 and P17. P1 and P17, bro. Not similar applications, my lord, were also made by first and second respondent, my lord, in respect of other properties. Their application got rejected, my lord. Merely, my lord, because their application was rejected, they started claiming not the rights in my property, my lord, which was in my unauthorized possession.
P17.
Yes, my lord. Exhibit P1 and P17, bro.
No, D series serial.
D series.
I have the records of OS 64. 64 alla?
64 alli.
Exhibit?
Exhibit P1 and P17, bro. They were produced by, my lord, the plaintiffs, that is the brothers themselves.
Now, where is your application? Since how many years did you claim you were in unauthorized occupation in your application?
From 3 years, my lord.
Where is the application?
That is not placed on record. Only the order granting, my lord, Sagulechit is part of the record, my lord. It is in my individual name.
No, that is there. But since when, what point of time you were in possession? It was granted to you when?
In 1978, my lord. After lapse of 3 years, my lord, from the oral partition.
What record did you produce so that you were in possession independently after 75?
No, because we had already separated, my lord, and we had partitioned. I saw
that the trial court has not accepted, the appellate court has not accepted because your sale deed, which is according to which you sold the property allotted to you, was not produced to indicate there was a partition.
Yes, but that is an admitted.
What document have you produced to show there was a partition?
It was, my lord, I only contended that, my lord, both, my lord, the first respondent and second respondent and appellant, they have all sold, my lord, the properties allotted to them.
Did you produce their sale deeds at least to show that they have sold, in which there's an indication that the property was partitioned and they got it in a partition?
No, it was not produced. No.
Then, on what basis do we come to the conclusion that there was a oral partition and that you were in possession independently after the partition?
No, they admit, my lord, that only 2 brothers, my lord, were separated. And, my lord,
merely because they're separated does not mean that there is a partition.
No, they got separate properties. One of the brother, my lord, relinquished his right by accepting money. That is Gopal Swami.
When was that?
That was in 1975.
Is that a registered release deed?
No, not by oral partition only, my lord, they separated.
So
because
if
they
that
had
is
only
so,
2 properties. Only revenue entries got changed by mutual consent, my lord. The revenue entries in respect of one particular property was registered in my name, and by virtue of, my lord, no objection given by me, the other property was given to them, Lord. That is how, Lord, the oral partition, Lord, we have done.
Did you produce a mutation extract to indicate that you had given your no objection and they had given their no objection?
Mutation extracts, Lord, around record. But I'll go through it, Lord, and then I'll make submissions tomorrow, Lord. Mutation MR registers, Lord, they're on record, Lord.
Have you given your no objection for change of the mutation? Do you admit the scientific partition? Then how did you get your name in respect of certain lands in your name mutated?
In respect of 149 Ramin Koppa village.
If all of you are living jointly, then the RTC should have been in the name of your elder brother. Why did it change in your name? Why? Why was it changed? So that means after oral partition, let us see your written statement. What was your defense? You are the plaintiff, alva? Gopala and Ishwara. According to the partition of the year 75, survey number 25 was divided into 3 portions, huh?
Two portions, my lord. 1 acre 11 guntas each, my lord. One was given to the appellant, and the other portion, my lord, was given to the Govind Swami, my lord. And PW2, my lord, their own witness, my lord.
Who is Govind Swami?
Govind Swami, my lord, is the other brother. He's not a party to the suit, my lord.
How can you maintain a suit for partition without the other two brothers? Where have you said so in your plaint? No. Your suit was for partition, isn't it? Where have you said in that suit for partition, the plaint, that there was an earlier partition, the 3 of you continued to be joined, 2 of them had gone out. Where have you said that in your plaint?
And my lord, that Govind Swami, my lord, was PW2. He has not supported their case, my lord. His own witness.
No, earlier partition ಬಗ್ಗೆ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ? Maybe in para 2. Para 2 what is the plaintiff 1 and 2 are younger brothers of defendant number 1. Defendant number 2 and 3 are the sons of the first defendant. Plaintiff's father died about 50 years ago. The lifetime of Tirumala Swami, his elder son by name Govind Swami, Pape were separated from the family. After the death of Tirumala Swami, plaintiff and defendant number 1 were living together. In fact, the plaintiff property was unauthorizedly cultivated the plaintiff and defendant number 1. He submitted the defendant number 1's elder brother. Where have you talked about that division of number 25? What is the mutation extract of number 25 in their favor? No, his case is number 25 was divided.
Yes.
Govind Swami got 1 share. And who else got the share in number 25?
Appellant, my lord. First appellant, my lord. That is Chinna Swami.
Independent.
First appellant, my lord. Chinna Swami, my lord. The plaintiff, my lord, in OS 333 and 332, my lord.
Where is the RTC produced to show that the name was transferred in their name?
They have not produced it, my lord.
No, why don't you produce it? To show that there's a partition. Even produce ಮಾಡಿದ document.
Grant certificate produce ಮಾಡಿದ್ವಿ exhibit D1 tax payer sheets. If my lord goes through, my lord, the evidence of my lord exhibit PW2, then my lord things will be clear now.
Exhibit PW2.
PW2, my lord, Govind Swami.
That is the gentleman who got 1 acre 11 guntas is number 25.
Yes, my lord.
Which paragraph?
last portion, my lord, of the cross examination.
ಏನಂತ ಹೇಳಿದಾರೆ?
All 5 brothers, my lord, they were in unauthorized possession, my lord, of the other lands, and only in respect of, my lord, 3 brothers, my lord, it was regularized. Other 2 brothers, that is first and second respondent, it is not regularized.
No, but he also talks about the partition, isn't it?
Yes, my lord, he also talks about partition, my lord.
If there is a partition,
Yes, my lord.
how is it established? He is supporting you.
Yes, my lord, he is supporting.
If you are saying that 1 acre 11 guntas number 25 was granted to them in the partition,
Yes, my lord.
then there should be a corresponding entry in the revenue records.
Corresponding entries are there, my lord, but it is not produced, my lord, on record.
Then what can we do? Appellate court is right then. If you don't produce anything to show there's a earlier partition,
No,
how can we rely upon just the grant certificate?
They sought for, my lord, partition. They sought for partition. Their suit is for partition. My suit, my lord, is for possession, my lord.
Now consider this aspect. All 3 brothers are staying next to one another in the same land. And you are expecting us to believe that there is a partition and you allowed them to stay in possession?
No, my lord, survey number 149, my lord, was granted to them, my lord, in the year 1975 partition, my lord. 149, that they have sold.
Where have you produced that to show that it was granted to them? Corresponding entry in the revenue records. Even you have sold one particular portion, number 25. What did you produce to show that the property was your separate property granted to you in the partition?
My lord, may kindly grant me 2 days time, my lord. I'll come up with, my lord. I'll physically come and, my lord, I'll convince. 2 days.
Number 9.
Serial number 9, my lord, I appeal for the respondent.
Number 9.
Vijay Krishna Bhatt.
GPA.
3 days back, my lord, matter was listed. He just wanted to confirm with his client, my lord, regarding that tenancy matter. If the tenancy is not allowed.
Vijay Krishna Bhatt. I'll pass it over once.
Filed by the first wife. Suit was filed by the second wife. Seeking partition. First court rejected. Second court allowed the second wife.
Plaintiffs are Nanjappa.
And defendants are first wife. First court dismissed the suit. Court allowed the appeal of the second wife. First wife's children are in appeal. The meantime, there were.
You are for the?
I'm for the applicant was purchased for entire property. The meantime.
ಕೆಳಗೆ ಬರ್ದಿದ್ದ ಇದ್ರಾಗಿಲ್ಲಲ್ಲ
There are how many second appeals? No appeals for the plaintiff.
I appear for it.
That is, your RSA is
My RSA is 663 of 2008.
663. The plaintiff in OS 2 bar 2006.
I'm in OS number 17 of 2000.
Which is the first suit? Was filed. Or they represented here. What happened in the trial court?
Allowed by the first court has allowed them.
No, who filed the appeal? Rangegoda filed the appeal or?
But I filed one appeal.
But did Rangegoda pay for an appeal or not?
Yes, my lord. One Savit Rama, my lord, filed. Third plaintiff, my lord, in OS number 2 of 2006.
If the original suit was filed by Rangegoda, Nanjamma, Savitramma, Bharati, their suit was dismissed.
Yes.
They did not prefer any appeal.
Savit Rama, the plaintiff number 3, my lord, filed an appeal. RA number 108 of 2006.
RA number 8. The others accepted. Plaintiff 1, 2, and 4 accepted. What happened to the RA?
I also filed an appeal. My lord, I am a plaintiff, my lord, in the.
I'll go by one. RA was what happened to the RA?
Two suits, my lord. OS 2 and OS 17 was filed by the second magistrate. That is two brothers.
I'll first go get the facts correct. OS 2 bar 2006 is filed by Rangegoda and 3 others. Now that was dismissed. RA was filed only by the third plaintiff, and that has been allowed against RSA 1722 bar 2007. The other suit is OS
17.
This was filed by no, this suit. What happened to this suit? RA
number 16 of 2006. 116 of 2000.
116. This has been allowed. Against which RSA? 1723. 1722 is against by Savitramma. This is by Kalegoda. The third second appeal?
That is filed by the plaintiff Kalegoda.
RSA 1723 is by Kalegoda.
RSA 1723 is by me. Both those appeals have been filed by Chennappa.
Here. 722 and 1723.
RSA 1722 is by? Give me the defendant's his rank in the trial court. Defendant number.
Defendant number 1.
In both cases.
In both cases, defendant one expert is the father and
Then the other RSA?
1723 also.
RSA 1723 is also filed by you. That is against the suit filed by Kalegoda. RSA 1722 is the second appeal arising out of the suit filed by appeal filed by Savitramma. Now, which is the third one? RSA 663.
It's an appeal filed by Kalegoda. And it only concerning the share allotment of the share mallet experiences. Only to that extent the share is.
So this is also against RA 116.
And this is against RA 116 of 2006.
663/18.
Then what has happened? There is one property measuring 2 acres, which forms the main item, which is the core of it. The other is the house. I, as a purchaser, I purchased all the shares of both the first wife and second, right? Except the appellant in 1163, that is Karnataka. So a small share of Karnataka.
I told them, why don't you purchase it?
I am willing to purchase it. I want to be close. I want my renting property. Perchance we could.
How much will you get?
I will get 27 guntas.
Suppose they pay the market value for 27 guntas, what is your problem?
It's an ancestral property, some kind of an emotion. That's my is already 70 years old. He wants to retain my love.
Are you capable of buying their other shares?
I will not get 27. That is why I have filed here. 92 guntas is my lord, the measurement of the first.
Your difficulty, Vivek, is you are a subsequent purchaser. You really have no right.
I'm waiting for eventuality, but one issue is, it is held by lords that Karnataka has no share, and I have exhausted. I will get the entire property. I have purchased the shares of the entire shares.
Even if his second appeal is dismissed, the share that is granted to him by the trial court becomes final.
Yes.
So to that extent, your purchase will be.
Yes. To that extent, I am protected because I purchased the shares of.
Only one land is involved in this second appeal.
One agricultural property, one house property.
I mean, let me complete there. That is survey number 44/1A.
Yes. And I purchased
2 acres, 12 guntas, and one house property. 30/40.
I have purchased 3 shares of the first one and almost 4 shares of the second one. Branches. Only Karnataka is the only share that I have to purchase.
Lucy Kalegoda is the propositors, correct? Then near 2 wives, Dodama and Kadama. The first one is Nanjamma. For Dodama, the first daughter according to the genealogical is Nanjamma. She is not a party here.
She is not a party. She is survived by Nagamma and Nala.
Page 113, is this correct or not correct?
Is correct.
Nanjamma. Is it an admitted fact that Nanjamma made issueless? The first daughter. Then Channappa, Nanjappa. Channappa is the and Nanjappa, second son. Nanjappa is D1, alva. The Channappa is D1. No, Channappa is D1.
Yes.
Nanjappa. Then second wife is Kadamma. She has one Ragegoda.
My lord, they are there for
Ragegoda. The 3 sons. Rangegoda na Ragegoda. Is a party here, Rangegoda?
Rangegoda is the first plaintiff.
Is the first plaintiff. I'll go according to OS 2/6. Rangegoda is the first plaintiff. Anjappa is the second plaintiff. Kalegoda, the other case. But in this suit, no, in OS 2/2006 is D3. Is also the plaintiff in OS. Also the plaintiff in OS 17/06. So one. Altogether 5 children. Altogether 5 children. Yaru? Yes, sir. Was that ground taken up in the trial court? Ammayamma? Ammayamma? They're alive? But they have children. Seven shares. No, 1/7 share ಬರುತ್ತೆ.
Even though they were not parties, I as a purchaser have secured a steel from them to Sarojamma by paying consideration. Those Akkayammas and Akkavas children.
Akkayamma and Ammayamma.
Ammayammas, yes.
When did they exhibit the registered?
It was 2019. By Nagamma. On
Who's Nagamma?
2019.
Who's Nagamma?
Ammayamma's
Partition suit.
first wife.
Nanjamma ಅಂತ ಹೇಳಿದೆ.
ಅದೇ ಅಮ್ಮಯ್ಯಮ್ಮ ದೊಡ್ಡಮ್ಮ's daughter's daughter.
ಯಾವ daughter's daughter? ಅಕ್ಕಯ್ಯಮ್ಮನ ಮಗಳ, ಅಮ್ಮಯ್ಯಮ್ಮನ ಮಗಳ. ಹೆಸರು ಏನಂದ್ರೆ? ನಾಗಮ್ಮ.
ಮಾಡಿಲ್ಲ, ಬಟ್ ನಾನು ಎಕ್ಸಾಸ್ಟ್ ಮಾಡಿಲ್ಲ.
Release date dated?
Date on 9/7/2019.
Pendency of the proceedings. Akkayamma also. Akkayamma has executed a release date. Is it you admit that Akkayamma?
No, my lord, there is no pleading until now, my lord, that not at all the case made out by the defendant. For the first time in this appeal, my lord, it is being. ಅಲ್ಲ ನಾನು ರಿಲೀಸ್ ಡೇಟ್ ಮಾಡಿ ತಗೊಂಡಿದ್ದೀನಿ. ಅಲ್ಲ ರಿಲೀಸ್ ಡೇಟ್ during the pendency of their I've taken a release.
No, but if they admit that Ammayamma and Akkayamma release the property, then it's easy. If they don't, then there's a problem.
ಅಮ್ಮಯ್ಯಮ್ಮದು ನಾನು have made the purchase. ಅಕ್ಕವ್ವದು there is children ಇಲ್ಲ. Right?
If it is a self-serving statement, then you are an outsider. How would you know? They are the ones they'll have to say. Whether the second wife's children or not. Like the Kalegodur ಜಮೀನ್ ತಾನೇ ಇದು. ಅವ್ರ ಸತ್ರ ಎಲ್ರಿಗೂ ಭಾಗ ಬಂದೇ ಬರುತ್ತಲ್ಲ.
Plaintiff when they filed this suit and also the defendant this is an ancestral property of the question, my lord, the capacity of the ancestral property of the Musikada, whether the second and children have a right or not.
Then matter requires admission because that question is before the Supreme Court. Whether illegitimate.
Even that issue, my lord. Even that issue is not borne by pleading. For the first time, they introduced it before the regular appellate court. Alert the Arya court, my lord, negated that contention because the marriage with Kadama had taken place prior to 1956. It was in the year 1940 that the second marriage took place. There was no bar for that. No, the point
There's a finding. There is a finding.
There is a finding before the appellate court saying that this will not be a capacity.
When according to you, Kadama got married, when you admit the relationship. How old is?
But both admit that this is an ancestral property.
How old is Channappa?
Channappa is 71 years old. So he's born somewhere in the year 1951.
And what about Rangegoda? Rangegoda? Then marriage will be prior to 56.
So far as the share is concerned, the stock of capacity is 50%.
So
I need to clarify that issue, my lord. Keeping that aside, there is any systematic
illa anta.
Lordship may admit it on that point, on that larger point. But we could bring.
No, if the finding is that it's prior to 56, then that question of law will not arise for consideration. Unless you were to establish something from the record to show that the marriage took place after 56. Then both the widows will together have to take one share. The period prior to 56.
Because marriage was valid.
Then all children will be entitled to an equal share.
Just examine the property is such a way, the shape of the property.
Now they know atta ಹಿಡಿದಿದಾರಲ್ಲ.
ನೀವು ಮೊದಲಿಂದ ಆಗಿದ್ದಿದ್ರೆ ಪರ್ಚೇಸರ್ ಮೈ ಲಾರ್ಡ್ ವಾಸ್ ದೇರ್, ಇಟ್ ವುಡ್ ಹ್ಯಾವ್ ಬೀನ್ ಅ ಡಿಫರೆಂಟ್. ಅಲ್ಲಿ ನಾವು ಫೈನಲ್ ಡಿಗ್ರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಡೆಯುವಾಗ ಮ್ಯಾರೇಜ್ second wife that makes all legal heir shares of second wife we are purchasing except Kale.
ನಿತೀಶ್ 13 ಗಂಟೆ ಬರುತ್ತೆ ನಿಮ್ಗೆ, 13 ಗಂಟೆ ಬರುತ್ತೆ. 92 ಗಂಟೆ 7 ಭಾಗ ಆಗ್ಬೇಕಲ್ಲ ನಿಮ್ಗೆ ಕೂಡ 7ನೇ ಭಾಗನೇ. If Ammayamma is the daughter,
there is no pleading, there is no evidence my lord that they are the daughters. For the first time they are all taking these contentions.
All right, we'll go by this. It's 13 guntas, or else
I just pass on my share, my lord. I have made a calculation of share.
18 guntas.
1136 is 27 guntas is my entry.
Yeah, we will assume you get either 1/7 or 1/5. If it's 1/5, it is 18 guntas. If it's 1/7, it is 13 guntas.
13 guntas. The point is notional partition as my mother's share also.
And when according to notional partition?
I just passed.
La date could have. When did Kalegoda die?
Usi Kalegoda died on 10/5/1970. Doddamma, my lord, the first wife, died on 27/4/1964.
27/4/1964.
Kalamma, that is the mother, my lord, of my client, died on 3/1/1990.
So when he died,
yes, mother,
there was a female heir left.
There were 5 sons who were there. Going by the co-partnership, each gets 1/6 share. Usi Kalegoda gets 1/6 share. Channappa, Nanjappa, Rangegoda, Nanjappa and Kalegoda gets 1/6 share each.
When he died, 1/6 ಬರುತ್ತಲ್ಲ ಎಲ್ಲರೂ.
ಹೌದು, 1/6 ಬರುತ್ತೆ.
1/6 ದಲ್ಲಿ ತಿರ್ಗಾ
what happens is, my lord, notional partition ಅಲ್ಲಿ 136 share ಆಗುತ್ತೆ.
1/6 plus 1/8.
1/6 plus 136. Because the 1/6 share of Usi Kalegoda has to be
You are
divided.
excluding Akayamma and Ammayamma.
Yes, I am excluding.
1/36.
1/36. So 1/6 plus 1/36 is 7/36.
7/36.
7/36.
You get 17.8 guntas.
7/8. Yes. Thereafter, my lord, what happens is Kalamma dies. Kalamma's 136 share, her 3 sons get. That is Rangegoda, Nanjappa and Kalegoda. This is what is listed by the first appellate court according. ಆಮೇಲೆ ನಂಜಪ್ಪ ತೀರೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. He has died issueless. So ಅವರ ಶೇರು ರಂಗೇಗೌಡಗೆ ಕಾಳೇಗೌಡಂಗೆ ಬರುತ್ತೆ. That totally, my lord, makes my share 11/30.
ಇಲ್ಲ ಇಲ್ಲ ಅವ್ರಿಗೆ ಬರಲ್ಲ ಬ್ರದರ್ ಅಂತಂದ್ರೆ ಫುಲ್ ಬ್ರದರ್ ಅಷ್ಟೇ ಹಾಫ್ ಬ್ರದರ್ Kadamma share you are saying will go to Rangegoda, Nanjappa and Kalagoda. Again Nanjappa died. Nanjappa died. Nanjappa share Rangegoda and Kalagoda. Plaintiff number 2 died. ಎಷ್ಟಾದ್ರೂ ಒಂದು 22 ಗಂಟೆ ಬರುತ್ತೆ. ನನಗೆ 27 ಗಂಟೆ, ರಂಗೇಗೌಡಂಗೆ 27 ಗಂಟೆ. ಅವ್ರಿಗೆ 19 ಗಂಟೆ 19 ಗಂಟೆ. ನೀವು ರಂಗೇಗೌಡರ ಅಪೇರ್ ಆಗ್ತೀರಾ? ಇವರು ರಂಗೇಗೌಡರ ಮಕ್ಕಳು ಆ ಬ್ರಾಂಚ್ ಗೆ. ನೀವು ಯಾರಿಗೆ ಅಪೇರ್ ಆಗ್ತೀರಾ? ಅವ್ರು ಇದಾರಲ್ಲ ಇವರು ಹಾಫ್ ಬ್ರದರ್ ತಾನೆ. So will you get anything from Nanjappa share? Correct. When he died, it will full blood will prefer to half blood. So Nanjappa share will go to his mother Rangegoda and Kalegoda. You none of you will get that share. How? Rangegoda, Kalegoda will get the share only if there are no class 1 heirs. They have class 1 heirs. Either way, you will not get anything. And the father died in 1970. When did Nanjappa die? Then so you're only fighting for Nanjappa share now. That is granted to you. Nanjappa's D2 share is granted to you, and you have not challenged that the suit was dismissed, correct? The suit was dismissed, and even Singham has released it in favor of Karnataka. Fair of when? When? To a suit alone.
Partition deed is not running on the plaintiffs, and once the trial court has
Are you sure you want to litigate to admit the appeal now? Go from. I have no. If they give you 27 guntas, they also give have to give everything to everybody else. So he gets it. Our partition treatment ಕೊಟ್ಟಿದ್ದಾರೆ. He is not losing anything. At 27 guntas ಅಲ್ಲಿ ಹೆಚ್ಚು ಕಡಿಮೆ ಮಾಡಿಬಿಟ್ಟು 27 guntas ನಲ್ಲಿ ಅಮ್ಮಯ್ಯಮ್ಮ exists. ಅಮ್ಮಯ್ಯಮ್ಮ is the daughter. They have not. But he has a point when none of you have raised that plea of either Ammayamma or Akkayamma being the daughters. You cannot diminish the share. We'll forget the shares for a minute. We'll forget the shares. He's on 27 guntas. He's a bit flexible. Are you prepared to give anything less than 27 guntas and close the matter to him so that the matter comes to an end? Ammayamma's so-called share, notional share that we have to allot to her. Considering that if they are willing to accept something less, I can examine that. Like 27 gunta ಬದಲು ನೀವು ಒಂದು ಆಫರ್ ಕೊಡಿ ಅಷ್ಟು ತಗೊಂಡು ಮುಗಿಸ್ಕೊಳ್ಳಿ. Are you prepared to give the land in the first place? Land ನಾವು ಕೊಡೋದು ಕಷ್ಟ ಇದೆ. Purchase the land. They are willing to pay money extra also and purchase it. You are not prepared. You can't force them to give up their ranch. We'll make an attempt. We'll make an attempt on that. Sure. But ನೀವು ಫಸ್ಟ್ ತಾವು ಹಾಕಿದ್ರಿ ಫಸ್ಟ್ ಪ್ಲೇಂಟಿಫ್ ಅಲ್ವಾ, ವಜಾ ಆದ್ಮೇಲೆ ಸುಮ್ಮನೆ ಆಗ್ಬಿಟ್ರಿ, ನೀವು ಅಪೀಲ್ ಹಾಕ್ಲಿಲ್ಲ. ಸರಿ, ಬಟ್ ಯು ಅಕ್ಸೆಪ್ಟ್ ದ ಡಿಸ್ಮಿಸಲ್. ಇಲ್ಲ ಹಾಕಿದ್ರು ರಂಗೇಗೌಡರು. First wife's branch cannot ride on the second wife's appeal. ನೀವು ಕಾಸು ತೊಡೋಕ್ ರೆಡಿ ಇಲ್ವಾ?
Willing to talk. Adeguda can be, I requested my learned friend, can bring his client. I'm trying to custody good side.
The parties submit that they would explore the possibility of a settlement, given the extent of land involved in second appeal. Facilitate such deliberations.
1 week, next week, one date happened. Parties present in there, then we put one.
Next week, I'm not checking, so you can do whatever you want to do.
Illa Friday, after the parties Friday. Council, name of council for implementing application.
Yeah.
Yeah, super.
Where's the application? Yeah. The name of the council who has filed the application for impleading be printed in the causes. Rectify the office objections.
Application. I suggested settlement ಆಗುತ್ತೆ telegraph to TD ಚಾರ್ಜ್
ಏನ್ ಮಾಡೋದು?
ಒಮ್ಮೆ ಟ್ರೈ ಮಾಡ್ತೇನೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಳೆ ಅವ್ರು ನೀವು ಅಪೇರ್ ಆಗ್ತೀರಾ?
Serial number 11.
ಅವ್ರು ಇನ್ನೊಂದು ವಾರ ಟೈಮ್ ಟ್ರೈ ಮಾಡ್ತಾರಂತೆ. 1 more week. Lawyer.
It is obvious, my lord, it is obvious that they would want to hear this matter. So
I can't help it.
That's right.
ಅದಕ್ಕೆ ಕಾರಣ ಇದು put in one more effort.
Next week.
Efforts ಮಾಡ್ತೀನಿ ಅಂದಾನೆ. ಇದನ್ನೇ ನಾನು ತುಂಬಾ ಮುಂದೆ ಹೇಳುದು.
ಶಿವಕುಮಾರ್. Next week.
Appearing for the respondent, my lord.
Shodaya.
My lord, in this matter, there is no substantial question itself, my lord. There was a prior partition in the year 2000.
Barley or Barley.
Appellate is the order. Filing the rights in order for sale for the ancestral properties. The first trial court declared this rule, declaring one for sale of the appellant in the ancestral property.
Relationship is not in dispute.
Not
Depend number 1.
1 to 4.
Brothers, huh?
Father and the brothers. Father, mother, and brothers. And fifth defendant is the purchaser, this lord.
D2 is your sister, right?
Yes.
No, is your mother.
Mother.
Trial court decreed this.
Trial court declared this rule. The first appellate court comes to the conclusion that in the Karnataka number 17 is the law. And on marriage, she ceases to pay the grandmother right of the mother.
Issue notice.
Legally.
Delay is nothing court listed.
Your lordship, I'm for the respondent, your lordship. Serial number 17.
No, I'm at 16. Delay, how can I grant you a stay? Notice order, man. We have time back. You are not present, so I said I'll ask you and then.
Whether I had filed the cross objection, that is not considered taken time to the objection. The appellate court, we had filed cross objection, that is not and model that.
Time back. Next week.
Next week. Oblige your lordship.
Motions not extended.
Interim order is extended, your lordship, in 17.
Yes.
Oblige your lordship. Oblige your lordship.
There is a plenty for defendant. Defendant number 1, All defendants. Look for injunction. Trial court decreed the suit. Affirmed it.
Now say that
Serial number 21, man.
18.
Sorry, man. Sorry, man.
since from the beginning they are not in position of damage.
But this is for violating the order of injunction.
There is no whisper about all along the letter, I violated the order. All along, since from the beginning. After the this one cannot legacy, they are claiming the property.
No, when the suit was filed, it was a vacant site.
It's a agricultural land.
No,
They are saying claiming that it's a vacant site.
page 76 says it's a vacant site. Was it your case that there was a house there?
No,
Let us see your defense.
sir, my defense is not my this is a property plus the this appellant, and by exchange deed, the appellant's father obtained this property. After that, my lord, without acquisition of the property, one sangha formed by the some villagers and allotted this site to the various persons, saying that my lord, that these are the that sangha is my lord, have no jurisdiction. And the block development officer will not conduct the Sangha development and allotted the site to the various persons without acquisition of any land. And thereafter, DC set aside the order, and that one is concerned to pay this is the exhibit. It is not in dispute, my lord, sir. We are the owner of the property. And without acquisition, they allotted this site, and thereafter cancel the grant.
What is your defense in the trial court?
Defense is that I am the owner of the property. Without acquisition, my property is concerned. They are claiming that it's allotted property. They are not in possession of the property. And one thing is they are saying that the claiming to Hakupatra. That Hakupatra is concerned that there is no validity. And they are not in possession of the property. The government is allotted the land in favor. What have to acquire the land? And then they have
This is a suit for injunction based on possession. You claimed that you are in possession. Trial court did not accept the plea. Appellate court has not accepted the plea. Now you are saying that they have admitted possession because they found an execution. That is your case now.
not only for
showing that, my lord, I am in possession of the
No,
property.
The application simply says that you had put up a construction in violation of the injunction order.
That one is concerned. Now saying that, my lord, say in exhibition only for a piece of evidence. I am showing that, my lord, since from the beginning they are not in possession of the property. I am in possession of the property. They are claiming that, my lord, is Hakupatra. I am claiming that, my lord, is the registered deed. And that, my
No,
lord,
you are claiming serial number 105. And the suit property is Kata number 17. Formed out as serial number 105. What have you produced to show that serial number 105 was your property?
Say the exchange deed I have produced, and RTC I have produced all RTC.
Exchange deed when?
1956. And thereafter, my lord,
Prior to 1956, in whose name was serial number 107 standing?
2156, my lord. Before that, my lord, is the Ananda Shastri. When Ananda Shastri was the owner of that property. After the exchange deed, my lord, Inam land. Thereafter, my lord, confirmed by the Inam Operation Act, my lord, after that, my lord, the rights is confirmed by the tribunal in my favor, in my grandfather's favor. Thereafter,
No, either the land was purchased by you on an exchange deed or it was granted to you. Which of the two is correct?
basically, it's 1956, my lord, we purchased the exchange deed between my grandfather and Ananda Shastri. And thereafter, my lord, as per the order of the tribunal,
Where is the order of the special deputy commissioner? In your favor?
Exhibit P7.
P5.
Only 5 cents owners, my lord, they are claiming those properties. Remaining 217 persons, my lord, they are not at all claiming. Only 5 cents is concerned, my lord, they are claiming the property.
ಇದು ನಿಮ್ದು ಕಾಂಟ್ರಾಡಿಕ್ಟರಿ ಪ್ಲೇ ಆಗಲ್ವಾ? You say 56 ಅಲ್ಲಿ you have purchased, then 77 you are saying that you are a tenant.
Because confirm the Inam land. The purchase that is concerned, my lord, the land is confirmed by the tribunal in purchaser name. That the order also I have produced.
Yeah, the exhibit.
Last one. This is the name of the applicant. Last paragraph, last exit.
Notice. Both the parties to maintain status quo. There discrepancy, है ना? It's a discrepancy in mentioning of the case number, the cost title, and in the pages of the judgment shall be ignored.
Yes, my lord.
Correspondent 1 and 2 is present, my lord. For the court.
My lord, I represent the appellant, please.
33% ಮಾಡಿದ್ರೆ ಆಗ್ಬೋದು ಅಂತ ಕೋರ್ಟ್ ನಮಗೆ ಹೇಳಿತ್ತು. The respondent married a two. So client
respondent number 2 is plaintiff before the voice.
ಏನಾಯ್ತು ಸಿದ್ಧಾರ್ಥನವ್ರೆ?
ಸ್ವಾಮಿ ಇಲ್ಲ, ನನಗೆ ಏನು ಮಾಹಿತಿ ಇಲ್ಲ.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಏನ್ ಆಗಲ್ವಾ?
ಅಲ್ಲ, ಇದು 19ನೇ ಮ್ಯಾಟ್ರು, ಸೀರಿಯಲ್ ನಂಬರ್ 19.
ಹೌದು, 19th.
ಇದರಲ್ಲಿ ಐ ಆಮ್ ರಿಯಲಿ ಸಾರಿ ಲಾರ್ಡ್. ಇದರಲ್ಲಿ ಅದು ನಾನು ಕರೆಸಿ ಅವ್ರಿಗೆಲ್ಲ ಹೇಳಿದೆ. ಲಾಸ್ಟ್ ಟೈಮು ಡೇಟ್ ಫಿಕ್ಸ್ ಆದಾಗ ಸಿಟ್ಟಿಂಗ್ ಇರ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ನಾವು ಅವ್ರನ್ನ ಕೋರ್ಟ್ ಮುಂದೆ ಹಾಜರು ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ಲಿಲ್ಲ.
ಏನ್ ಮಾಡೋದು?
ಒಂದು ದಾವಣಗೆರೆ ಅಲ್ಲಿ ಇದಕ್ಕೆ ತಾವು ಕಳಿಸ್ಬಿಟ್ರೆ ಅಲ್ಲೇ ಏನಾರು ವರ್ಕೌಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
The council submit that this would be an eminently fit case for settlement in view of the said statement. The matter is referred to the mediation center. The mediation center Davangere. The parties should appear before the mediation center Davangere on date. Any Saturday, Sidmarnore?
Any day, any day it can be.
March 19th.
Please, please.
19th of March. Without expecting any further notice from the minister. 19th.
Please, Mano.
Super injunction.
Petition. Also decreed in the suit is decreed also nothing. But except one item.
Have item.
Number 10/1 item.
Number
10/1. Item number 4 RA is not the affected parties.
Item number ಯಾವುದು?
Item number 4.
ಮೇಲ್ಕೋಟೆ. ಡಿಗ್ರಿ ಹಾಕಿಲ್ವಾ? Trial court granted decree in all the appellate court dismissed only respect of item number.
Item number 4 is item number 2, serial number 10/1.
Item number 4 matra. What is item number 4? So number 10/1. Why did the appellate court dismiss this? Page number?
Case 41 Case 41 there are 33 below below 3 lives. Define 14 who is the one of the purchase of the suit.
No. Why did they refuse in respect of item number 4? When did he purchase?
See purchase.
Yavaga?
Very clear 2000 when the case is filed 2007. Rent from the property.
Where is the discussion regarding item number 4? No, that is 2003. Then automatically it stands saved, isn't it? ಯಾವಾಗಾರ ಫೈಲ್ ಮಾಡಿರ್ಲಿ. When was the suit filed? Before the suit was filed, she has sold. You filed the suit on 27th of May. 21st, she has sold. Then
that is one of my uncle, he was 90 years old that time. Don't know when they have taken it. She's one of the relatives of the family. Appellate is one of the relatives. The great petition is another. All the revenue records stand in the name of Chandra.
But how can that purchase be saved? How can you challenge that purchase if it's prior to that December 2004? Adrante, that has been saved. Tane.
Joint venture property, executor of the share deed, Chandra, my uncle has stated before the court, cheated me, joint venture property.
ಅವ್ರು ಏನಾರು ಹೇಳ್ಕೊಳ್ಳಿ, ಅವ್ರು ಬೇಕಾದ್ರೆ ದಾವ ಹಾಕೊಳ್ಳಿ, ಅದನ್ನ ಚೀಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರನ್ನ. ಅವರು ಆರಾದ್ಮೇಲೆ ಎಲ್ಲರೂ ಚೀಟ್ ಮಾಡಿದೆ ಅಂತ ಹೇಳೋದು. ಬಟ್ when you file the suit, you are Munyappa alva?
Munyappa. He also died when the issue is filed.
Who sold the property? Which defendant sold the property? Chandrayappa. In Engagate, how can that sale be invalidated now? Even if it is joint family property, any alienation made prior to that particular date can't be examinable. And you're a male. She noticed. ಎಲ್ಲರಿಗೂ ಬೇಕಾ ನೋಟಿಸ್? ಎಲ್ಲರೂ ಬೇಡವಾ? Item number? Lala. Who's the D13 sale ಮಾಡಿರೋದಲ್ವಾ? In favor of? When did he sell it? 2003 ಅಲ್ಲಿ. Chandrayappa sold the property. ಯಾರು ಎಷ್ಟನೇ ಡಿಫೆಂಡೆಂಟ್ ಅವರು? 13 is a seller. 14. That is Papamma. ಇಲ್ಲಿ ಎಷ್ಟನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವರು? ಮುನಿಪಾಪಮ್ಮ ಅಂತ ಇದೆ. For the present, issue notice only to the respondent number 1. ಬರೀ ಒಬ್ಬರಿಗೆ ಮಾತ್ರ ನೋಟಿಸ್ ಮಾಡಿದ್ದೀನಿ. Status quo to be maintained in respect of the suit properties.
For injunction, declaration, and also cancellation of
You are the defendant.
and the defendant.
Channa Mallikarjuna.
Is one of the property as per the CLD dated 2027.
My lord, back to paper respondent number 1, my lord. My lord.
Yes.
Sick 1 week time, my lord, next week.
ಖಾತಾ ಮಾಡ್ಲಿಕ್ಕೆ property is also there, my property is also there. He is trying to claim both the property. That's why private property is this. I have no objection enjoying this property. So by producing one sale, he is trying to get khata in respect of two properties. That is the problem.
Now time ಕೇಳಿದ್ರೆ ಕೊಡೋದಾ ಬೇಡವಾ? ಏನ್ ರೀಸನ್ ಹೇಳಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹೇಳಿದ್ರು.
ಪ್ರಾಪರ್ಟಿ ಅವರು ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಖಾತಾ ಮಾಡ್ತಾರೆ. ಎಲ್ಲರೂ ಕೊಡ್ಕೊಂಡು ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದೇ ಒಂದು ಸ್ವಲ್ಪ ಸ್ಲೈಟ್ ವೇರಿಯೇಷನ್. ಅದಕ್ಕಾಗಿ ಖಾತಾ ಅರ್ಜಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮೇಂಟೈನ್ ಸ್ಟೇಟಸ್ ಕೋ ಅದನ್ನ ನೋಡಿದ್ ಮಾರಿಯಪ್ಪ.
ಸ್ವಾಮಿ ಇಲ್ಲ ಸ್ವಾಮಿ ಫ್ರೈಡೆಗಾದ್ರೂ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ. ಕೆಲವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನನ್ಗೆ ತಂದ್ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ನಮ್ಮ ಕ್ಲೈಂಟ್ ಸ್ವಾಮಿ. ಫ್ರೈಡೆ ಆದ್ರೂ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ.
ಹೋದ್ಸಲ ಟೈಮ್ ಕೊಟ್ಟಿದೆ ಅಲ್ವಾ ನಿಮ್ಗೆ?
ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ಬಿಕಾಸ್ ಸಮ್ inconvenience my lord. It is true my lord. Last time I saw time. It is true. Friday.
ಹೈಕೋರ್ಟ್ ಇಂದ ಸ್ಟೇ ತಂದ್ರೆ ಮಾತ್ರನೇ ನಾವು ಇದು ಮಾಡೋದು, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ದಯವಿಟ್ಟು
call this matter next week. Till then both the parties to maintain status.
My lord, one submission my lord.
In ಎಲ್ಲರ application R3
ಗೆ
who's R3 notice ಹೋಗಿಲ್ವಾ? Issue notice on IA 234 of 21.
Appear for the appellant.
My lord,
this is a suit for partition. ಹೆಣ್ಮಕ್ಳನ್ನ ಕಂಪ್ಲೀಟ್ ಇಗ್ನೋರ್ ಮಾಡಿ ಪಾರ್ಟಿಷನ್ ಗಂಡ್ ಮಕ್ಳ ನಡುವೆ ಆಗತ್ತೆ. ಒಂದು. ಎರಡನೇದು ಗಂಡ್ ಮಕ್ಳು 2 ಪ್ರಾಪರ್ಟಿನ ಸೇಲ್ ಮಾಡ್ತಾರೆ. ಕೋರ್ಟ್ನವ್ರು ಅದನ್ನ ಒಪ್ಕೊಂಡು ನನ್ನ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ. ನನ್ನ ಸೂಟು
ಯಾವಾಗ ಸೇಲ್ ಮಾಡಿದ್ರು?
ಎಲ್ಲ ಸೂಟು ಆದ್ಮೇಲೆ. ನನ್ನ ಹತ್ರ ಎವಿಡೆನ್ಸ್ ಇದೆ, ನಾನು ಹಾಕ್ಬಿಟ್ಟು ಮಾಡ್ತೀನಿ. ನಾನು ನಾಳೆ ಮಾಡ್ತೀನಿ, ನಾಳೆ ಅಥವಾ ನಾಡಿದ್ದು.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
respondent number 1 for partition and supply solutions. So for relationship, you can tell me Chiknayamma and Kanamma, husband and wife. 9 minutes.
ಹಾಕಿದರಾ? ಜಿನೋಜಿಕಲ್ಟ್ರಿ ಹಾಕಿದರಾ? ಜಿನೋಜಿಕಲ್ಟ್ರಿ ಹಾಕಿದರಾ?
ಅವರು there is no dispute so far as the relationship.
Who's the plaintiff? FDP ಮೇಲೆ ಇದು FDP ಮೇಲೆ suit was decreed. Partition was decreed 19 1/9 share
Yes.
in 1 acre 13 guntas.
Claim is Malad, 3 acres, 3 guntas.
ನೀವ್ಯಾರು plaintiff ನಾ? 8.5 guntas ಬರುತ್ತೆ ನಿಮ್ಗೆ. 1/9 ಅದೇ ಒಟ್ಟು 1 ಎಕರೆ 37 ಗುಂಟೆ, 1 ಎಕರೆ 13 ಗುಂಟೆ.
5 ಗುಂಟೆ. Property in the name of rest of the property is not physical property. Other property also sold by all the time.
ಇಲ್ಲ ಇವಾಗ ನೀವು ಈ ಡಿಗ್ರಿ has become final 1/9 in survey number 7 ಅಷ್ಟೇ. 1 acre 13 guntas ನಿಮ್ಗೆ 9 ಭಾಗ ಕೊಡಬೇಕು. ಕರೆಕ್ಟ್. ಸೊ ನಿಮ್ಗೆ 1 ಎಕರೆ 13 ಗುಂಟೆಯಲ್ಲಿ ನೀವು 5.8 guntas ಕೊಡಬೇಕು. ಕರೆಕ್ಟ್. ಎಲ್ಲಿದೆ?
There is no schedule first of all. So for 1 acre 13 guntas is concerned, there is no schedule.
ಎಕರೆ 13 ಗುಂಟೆ ಶೆಡ್ಯೂಲ್ ಏನ್ ಬಂತು?
Schedule 3 acre 3 gunta ಇದೆ. 1 acre 13 gunta. ಇದು main ನಮ್ಮದಲ್ಲ.
ಇದೆಯಲ್ಲ
1 ಎಕರೆ 3 ಎಕರೆ 3 gunta ಶೆಡ್ಯೂಲ್.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಯಾಕೆ 1 ಎಕರೆ 13 ಗುಂಟೆ ಅಂತ ಹೇಳಿದ್ರು? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಯಾಕೆ ಹೇಳೋದು 1 ಎಕರೆ 13 ಗುಂಟೆ ಅಂತ? ಏನಕ್ಕೆ?
Page number 122, madam. 122. It is hereby declared that the plaintiff is assigned to 1/9 share in 1 acre 13 guntas of consideration. 1 acre 13 guntage schedule. ಅದು 3 acre 3 guntage schedule.
ನೀವ್ಯಾರಿಗೆ?
I am for appellate.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿ? ಇವಾಗ ಏನ್ ಗಲಾಟೆ ಮಾಡಿದ್ರು?
ನಂದಿಷ್ಟೇ ಸರ್. ಇವೆಲ್ಲ objection to ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇವೆಲ್ಲ 3 ಎಕರೆ 3 ಗುಂಟೆಯಲ್ಲಿ ಇವಾಗ 18 ಮತ್ತು 90 ಪಾಲು ಪಟ್ಟಿದ್ದಾರೆ. ಪಾಲು ಪಟ್ಟಿ 18 ಮತ್ತು 1990 ಇವೆಲ್ಲ ಅದರಲ್ಲಿ so far as ಕಾಳಮ್ಮ is concerned, plaintiff mother ಅವರಿಗೆ ಇವೆಲ್ಲ 1 ಎಕರೆ 20 guntas. ನನಗೆ so far as appellant father is concerned 1 ಎಕರೆ ಕೊಟ್ಟಿದ್ದಾರೆ. and ಸಾವಿತ್ರಮ್ಮ and ಸೋಮಶೇಖರ್ is concerned 1 ಎಕರೆ. ಮದುವೆಗೆ ಅಂದ್ಬಿಟ್ಟು ಕಾಳಮ್ಮ ಮೇಂಟೆನೆನ್ಸ್ 20.
ಅದೆಲ್ಲ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮಾಡಬೇಕಿತ್ತು, ಮಾಡಿಲ್ಲ.
ನಂದು ಪ್ರೆಸೆಂಟ್ ಇವಾಗ ನಂದು 1 ಎಕರೆ ಏನಿದೆ ಸೊ ಫಾರ್ as partition deed ಪ್ರಕಾರ ಪಾಲುಪಟ್ಟಿ
ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಇವಾಗ ಕತೆ ಬರೋದೇ ಇಲ್ವಲ್ಲ?
ನಾನು ಬರೋದಿಲ್ಲ. ಒಂದು ನನ್ನ 1 ಎಕರೆ ಯಾರು ಬರಲಿಲ್ಲ. ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಈ ನಂದು 1 ಎಕರೆ ಜಮೀನು ಸೊ ಫಾರ್ as 1 ಎಕರೆ is concerned 1 ಎಕರೆಲಿ ಬಂದು ಅವರು ಇದು FDP ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್.
There is a commissioner report.
Lower court itself ಅದು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಬರೋದಿಲ್ಲ. ಪೇಜ್ ನಂಬರ್ 54.
You have not filed any objections to the commissioner report.
ಇರ್ಬೇಕು ಮತ್ತು
ನೋಟಿಸ್ ಜಾರಿ ಮಾಡೋಕೆ
ಇದು ನೋಟಿಸ್ ಜಾರಿ
ಎರಡು ಕೇಸ್ ಇಲ್ಲ.
ಅದನ್ನ ನಾನೇ ಬಿಟ್ಟಿದ್ದೆ ಅನ್ಸುತ್ತೆ.
ಈ ಡೇಟಲ್ಲಿ ಇವತ್ತಿನ
ಯಾವ 20 ಇದೆಯಾ?
20 ಸಂಡೇ ಇತ್ತಲ್ಲ.
ಶಿವಕುಮಾರ್ ನಿಮ್ ತಂದೆನಾ? ಶಿವಕುಮಾರ್.
ಶಿವಕುಮಾರ್ ಅಲಿಯಾ ಶಿವಕುಮಾರ್ ಅಲಿಯಾ ಶಿವನ್.
He has appeared ಅಲ್ವಾ?
ಇಲ್ಲ ಅಪೇಡ ನಂದು ಇವನ ನಂದೇನಿಲ್ಲ ಸರ್. ನಂದು 1 ಎಕರೆ ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ಸಾಕು. ದಟ್ ಈಸ್ ಮೈ ನಂದು 1 ಎಕರೆ ಬರಬಾರ್ದು. ನಂದು ಶೆಡ್ಯೂಲ್ ಏನಿದೆ ಅದು ಬರಬಾರ್ದು.
Was he issued with the notice in the FDP? Where do I get that? Does the appellate court say that he was served with the notice? $20. 77. $70. 3/4/2013. ಇಲ್ಲಿದೆಯಾ? ಎಲ್ಲಿ ಓದ್ತಿದ್ರೆ? Where are you reading? Page 77 is the order sheet dated 3/4/2013. Steps and objection by ಅಂತ ಹಾಕಿದ್ದಾರೆ. Sappa and in Kansalwala plaintiff, it is on 14/12/2012. Plaintiff absent, notice to R2 ABC, R3 R6 served, R6 reported dead, R2 B and R4 present, and praised time to engage counsel. Son R5 advocate filed wakalat for R5. Steps and objections. R2B ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ ಅಲ್ವಾ ಅವರು? R2B and R4 present. Why are you saying that the Shivkumar was present? Because Shivಣ್ಣ ಒಬ್ಬ 13 ಇದ್ದಾನೆ. ಶಿವಣ್ಣ R13. Shivkumar notice ಹೋಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ದಾರೆ. What does the appellate court say about service of notice? ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿತ್ತೋ ಇಲ್ವಾ?
ಸರ್ವ್ ಆಗಿಲ್ಲ ಸರ್.
Where? Show me that paragraph that he has been served. ಬೇರೆ ಎಲ್ಲಿ ಓದ್ತಿದ್ರ? According to the appellants. So there are two Shivkumars, isn't it? The appellate court has not considered his R3. There is one Shivanna D13, R13. Because the order sheet, if you see, says notice to R2, ABC, R3, R6, and R3. No, R1, ABCD, R6 served. R6 reported as dead. R2B and R4 present. R2B is Bhadramas and R4 is Girjamma. And one counsel files Vakalat for R5, that is Ratnam. You will get the notice. The issue notice is that Admal yellow appear agidaranto. There are two, there's one Shivkumar and one Shivanna. Is this R13 or R3? Because the presiding officer makes a specific reference to who is present. He says R2B and R4 present. Does not talk about R4 or R3. D3 endetiga Varas Jari and Takida. When did he die?
2015.
All for records. In FTP. 35/2012. Now, office objections are noted. 2 weeks to comply with the office objections. Yeah. Entry model to continue the next date of hearing. But until you are able to show me that he was served. Malappa.
Please, Malappa. Lord, first defendant's appeal. There is a delay of 127 days, Lord, in filing the appeal. Lord, the appellant is aged, Lord, 80 years.
Suit for injunction, huh?
Suit for injunction. Trial court dismissed the suit. First appellate court reversed the judgment.
You are for defendant number?
First defendant.
Subbaraidu.
Please, no.
What is the claim?
Lord, the outcome of the decree passed now by the first appellate court, it amounts, Lord, granting decree against the provisions under section 135 is bar suit against the public officer, that to mean revenue officer, regarding maintainability of the entries.
No, this is only an injunction granted to restrain him from their possession.
No. Thing is, Lord, his claim, Lord, in the suit against the Tahsildar not to, Lord, affect entries in the name of first defendant.
There is no such decree granted. The decree at page
Well,
number
that's
29.
what the operative portion doesn't speak, but the prayer sought is against the Tahsildar only to that extent.
Either that is not granted.
Otherwise, there is no decree request to be passed, not against the Tahsildar. There was no relief at all.
There is no decree against the Tahsildar. The decree is only against D1 and D2.
For that, if it is so, my lord, there cannot be any decree against me for the reason that, Lord, the trial court has clearly held that, Lord, the plaintiff has not asserted any interference on my part.
What does the appellate court say for giving the decree?
Lord, my submission, Lord, I may be permitted to read, Lord, the finding of the trial court where, Lord, the suit came to be dismissed, para 13. Relevant portion, Lord, para 13, running page 42, internal page, Lord, 10 of the trial court judgment. Even in the plaint, Lord, that nothing was asserted saying that any attempt on my part to interfere.
Then how does the decree affect you?
No, it is not affecting. Granting itself is void.
All right. If you are not interfering, you have nothing to worry.
No, it is not that, Lord, I am also having property. It causes me, Lord, the greater impact. I am a Bajudar. I am holding property, Lord, more than 4 acres of land. Lord, it affects in enjoying, Lord, the said property.
Please read paragraph 16 of the appellate court's order. There is a clear allegation just about paragraph 16. This the plaintiff the defendant 1 and 2 in collusion revenue officials.
It is to be noted that the defendant number 4, Tahsildar Channagiri, has clearly admitted in his written statement in para number 3 of the written statement. ದಾವಾದ 3ನೇ ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳಿರುವಂತೆ ವಾದಿಯು ಸರ್ವೆ ನಂಬರ್ 52/9, 52/10 ಮತ್ತು 52/10ರ ಪಶ್ಚಿಮದ ರಸ್ತೆಯಿಂದ ಪೂರ್ವದ ಹಳ್ಳದವರೆಗೆ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿರುತ್ತಾರೆ ಎನ್ನುವ ಅಂಶ ನಿಜವಿರುತ್ತದೆ. Nobody disputes it.
And then please read para 16.
From the perusal of the above, the government authority, that is the Tahsildar performing his government function, has no ill will or animosity or favor of unfavor against any party. And it is to be noted that DW1 has clearly admitted about the position of the plaintiff with respect to the suit schedule property. And this the trial court in its judgment in para 12 of the said judgment has relied upon exhibit P14, under which the plaintiff got the suit property along with the boundary, as well as exhibit P9 and 11 and mutation regarding exhibit P12 to 13, reason to the effect that the plaintiffs are in possession of the suit property. And the trial court also recited a written statement of the defendant number 4, wherein the Tahsildar admitted about the plaintiff being in possession of the suit property. And the trial court also gone through the deposition of defendant number 2, DW1, wherein he has admitted about the position of the plaintiff in the suit property. And hence the trial court was correct in coming to the conclusion regarding the plaintiff being in possession of the suit property. When the trial court had come to the conclusion, come to the correct conclusion that the plaintiff was in possession of the suit property. But while discussing issue number 2 to 4 in panel number 13 to 16 of the said judgment, had reason to the effect that the defendant number 3 to 6, being the revenue official, and as per the Karnataka Land Revenue Act, the revenue officials are empowered with their own duties and responsibilities, and that the revenue officials.
You admitted their possession, therefore trial court is only injuncted you.
ನಾನು admit ಮಾಡಿಲ್ಲ, ತಹಸೀಲ್ದಾರ್ admit ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ that cannot be
you have
used
also
as a weapon
admitted.
against me.
You have also admitted.
No. The first defendant has never admitted that fact.
What is your claim over 52/9 and 52/10?
But, my defense is, admittedly, I am having not 4 acres of land abating to the suit share property. The boundary given by the plaintiff overlaps my property. If that being clarified, not absolutely, I can't have any grievance at all.
Your claiming is 52/A, 52/B, 52/C. You are in no way concerned with 52/9, 52/10.
No, it is not that. The measurement, the boundary even, it is not survey number. Survey numbers is not dispute. It is the measurement and boundary given.
Not if you admit possession, Mr. Malappa.
ಅಲ್ಲಲ್ಲ ನನ್ನ ಪೊಸಿಷನ್ ಅವ್ರ ಪೊಸಿಷನ್ ನಾನು ಅಡ್ಮಿಟ್ ಮಾಡಿಲ್ಲ, ತಹಸೀಲ್ದಾರ್ ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ತಹಸೀಲ್ದಾರ್ ವಿರುದ್ಧ ಆರ್ಡರ್ ಆಗ್ಬೇಕು ಹೊರತು ನನ್ನ ವಿರುದ್ಧ ಹೆಂಗಾಗ್ಬೇಕು?
ಇಲ್ಲ, ನೀವೇ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ?
ಇಲ್ಲ ನನ್ನ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ I can read my return statement. I can read my return statement which has been extracted by the trial court. Your Lordship may kindly see, Lord, the para 3 of the judgment. Para 4, I'm sorry, para 4. My defense is very clear.
Your defense, why did the appellate court say come to paragraph 16? It is to be noted that DW1.
ತಹಸೀಲ್ದಾರ್ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ. ತಹಸೀಲ್ದಾರ್ ಒಪ್ಕೊಂಡ್ರೆ
ಅದರದಲ್ಲ, ಅದು ಕೆಳಗಡೆ ನೋಡಿ. It is to be noted that DW1 has clearly admitted about the possession of the plaintiff with respect to the suit property.
ಅದು ಎಲ್ಲಿದೆ? ಇಲ್ಲ, ಅದು DW2 in his evidence he admits about that fact. DW2 is none other than Tahsildar.
Where is the deposition of DW1?
ಇಲ್ಲ,
where is the deposition of DW1?
ನಾನು ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ.
DW1 KB Ravi Prakash ಯಾರು?
Defendant number 2.
Defendant number 2. You appear for both D1 and D2.
ಅಲ್ಲ, ನಾನು ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ ಇಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿದ್ದೀನಿ. ನನ್ನ ರೈಟ್ಸ್ ಇರೋದು ಡಿಫೆಂಡ್ ನಂಬರ್ 2 ಗೆ ಏನೂ ರೈಟ್ಸ್ ಇಲ್ಲ, ಯಾವ ಪ್ರಾಪರ್ಟಿ ಮೇಲೂ ರೈಟ್ಸ್ ಇಲ್ಲ.
ಮತ್ತೆ ಜಾಯಿಂಟ್ ರಿಟರ್ನ್ಸ್ಮೆಂಟ್ ಯಾಕೆ ಹಾಕಿದ್ರಿ ಮತ್ತೆ?
ಅಲ್ಲ, ಅವರು ಏನಂದ್ರೆ ಲಾಯರ್ ಒಬ್ರನ್ನ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ, ಒಂದೇ ಒಂದು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ, ಈ ತರ ನೀವು ಹೇಳಕ್ ಆಗಲ್ಲ ನೀವು.
ಅಲ್ಲ, ಅದ್ ಬಿಟ್ರೆ ಮಿಕ್ಕಿದ್ದೇನೋ ಹಾಕಿ ಸಾಧ್ಯ ಇಲ್ಲ.
You file a suit for declaration.
No. My request before this honorable court, Lord, let there be, Lord, Tahsildar may kindly, my request before this honorable court, let the Tahsildar be directed to fix the boundary.
No. You file a separate proceeding for that.
ಅಲ್ಲ, ನಂದೇನಾಗಿದೆ ಈಗ ತಿಂಗಿ, the person who could not identify his property has gained the order of the court, and I had my property, everything is settled. I have to file separate suit for declaration now. That is the curse.
You have
there is no dispute with respect to my property is concerned. In his plaint itself, he has admitted that I have got the property. ನಾನು ಅವ್ರದ್ದು plaint ನ ಓದ್ತೀನಿ. It is extracted in the judgment of the trial court itself. He has clearly admitted that I have got property, 4 acres of land adjacent to his property.
You also admit, come to page number 99.
ಇಲ್ಲ, ದಯವಿಟ್ಟು ಪ್ಯಾರಾ 3 ನನಗೆ ಓದಕ್ಕೆ ಅವಕಾಶ ಕೊಟ್ರೆ ನಾನು ಅವ್ರ ಕ್ಲೈಂಟ್ ಅಲ್ಲೇ
ಆಮೇಲೆ ಓದಕ್ಕೆ ಅವಕಾಶ ಕೊಡ್ತೀನಿ. ಕಮ್ ಟು ಪ್ಯಾರಾಗ್ರಾಫ್ 12 in the trial court's judgment, page number 99, about 6 lines from the bottom. The sentence starts from apart from the said documentary evidence.
Paragraph, Swami.
Paragraph 12, trial court judgment.
Alla, paragraph 12, trial court do.
Page, internal page 9.
Please, madam, please.
In page 99.
Please. It is relevant to note that it is undisputed that the plaintiff are the owners.
Last 5 lines. Apart from the said documentary evidence.
Furthermore, the defendant number 4, Tahsildar Channagiri Taluk, in his written statement, meticulously admitted the possession of the suit property by the plaintiff. Apart from the said documentary evidence, the DW1 in his cross-examination clearly admitted the position of the plaintiff over the suit property based
Then,
on the above.
How can you deny injunction?
Swami.
How can you deny injunction in the light
No,
of this?
trial court denied injunction, saying that not there is no pleading to say that we have interfered.
Or DN Bekila, anything else? You separate dawa hakole. Nimena boundary dispute idre.
ಅಲ್ಲ ತಿಂಗಿ ನನ್ನ ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಶ್ಯೂ ನಂಬರ್ 3 ಮೇಲೆ ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಗೆ ನೆಗೆಟಿವ್ ಫೈಂಡಿಂಗ್ ಇದೆ.
ಅದು ಇದ್ರ ಮೇಲೆ trying to create revenue documents.
ಪ್ಲೀಡಿಂಗ್ಸ್ ಇಲ್ಲ. ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಇಲ್ಲ.
Issue number 3 is relating to revenue documents, creating of revenue documents. That is all. Not in relation to anything else. ನೀವು boundary dispute ಇದ್ರೆ ಇನ್ನೊಂದು ದಾವಾ ಹಾಕೊಳ್ಳಿ declaration ಗೆ. I'll make that clear.
ಅಲ್ಲ ನಾನು ಅದನ್ನೇ ತಮ್ಮ ಮುಂದೆ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾ ಇರೋದು. ಇಶ್ಯೂ ನಂಬರ್ 3 ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ ರೆವಿನ್ಯೂ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ. ಈ ರೆವಿನ್ಯೂ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮೇಲೆ ಈ ರಿಲೀಫ್ ನ ಕೇಳಲಿಕ್ಕೆ ಸಾಧ್ಯನೇ ಇಲ್ಲ. ಸೆಕ್ಷನ್ 135 ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್ and there is no pleading with respect to interference concern and no issues framed against that. Interference issues illa.
All right, anything else? This is a second appeal by the first defendant. Suit for injunction was filed.
Nanna request, I'm sorry to not say, not my request. ನಾನು ಯಾಕೆಂದ್ರೆ ನಾನು ಈಗ ಮುಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೀನಿ. ನನ್ನ ಪಾಯಿಂಟ್ ಒಂದೇ, ಅದ್ರ ಮೇಲೆ ಇಶ್ಯೂಸ್ ಆಗಿಲ್ಲ, ಡಿಕ್ರಿ
ಮಾಡ್ತೀನಿ.
ಅದ್ರ ಮೇಲೆ ಒಂದು ಸ್ವಲ್ಪ ತಾವು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡೋದು ಸಾಕು.
Contending that they were the owners of land bearing serve number 52/9 measuring 3 acres and serve number 52/10 measuring 2 acres 20 acres, which are both situated at Procedural village, Channagiri Taluk, Davangere district. It was their case that they had purchased item number 1 under 2 registered sale deeds in the year 1993 and item number 2 a sale deed dated 18/9/1989. And ever since they were in possession. It was their further case that the first defendant had purchased land since number 52/A, B, C, measuring an extent of 5 acres, and had sold the entire land and migrated to Bellary district. It was stated that though first defendant had no property in some number 52/A, B, C. The first defendant in collusion, defendants 3 to 6 were trying to create surveyed documents. And in order to create the documents, defendants 4 to 6 had trespassed upon the property and were interfering with the plaintiff's possession. And hence the plaintiff was constrained to file the suit. Defendants 1 and 2 filed a common written statement, while defendant number 4, the Tahsildar, filed a separate written statement. The defendants 1 and 2 denied the plaintiff governments and also the boundaries of this. They set up first defendant had purchased 3 acres in cell number 52 bar capital A on 28/5/83, 3 acres in cell number 52 bar capital B on 26/2/82, and 3 acres in cell number 52 bar capital C on 16/10/78. And out of the said extents purchased, he had sold 2 acres in cell number 52 bar A in favor of Bala Shaubhagya Lakshmi, 1 acre 20 guntas each in cell number 52 bar B and 52 bar C in favor of Balasu Srinivas, and was in possession of the remaining 4 acres. Pledged that in order to grab the property of these defendants, the 4 defendants was in possession of land bearing cell number 52 bar 9, 2 bar 10 towards the road from west to the Allah on the east. The trial court, on consideration of the evidence adduced before it, came to the conclusion that the plaintiff had proved that they were in possession as on the date of the suit. It, however, concluded that interference by defendants 1 and 2 had not been proved. It also came to the conclusion that defendants 3 and 4 were not creating revenue documents in favor of defendants 1 and 2. Thus, after finding that the plaintiff was in possession, the prayer for injunction was refused on the ground that there was no interference by defendants 1 and 2. The plaintiffs, now being aggrieved, preferred an appeal. In appeal, the appellate court concurred with the finding that the plaintiffs had proved their possession over the suit property. The appellate court disagreed with the trial court regarding interference and noticed that there was a clear averment in the plaint that the defendants were interfering with the possession of the plaintiff or the suit property. The appellate court noticed that DW1 in his cross-examination had also admitted that the plaintiff was in possession of the suit property. It also noticed that the defendant was present along with the revenue officials on the suit property for the survey, and that by itself indicated that there was an intention to interfere with the plaintiff's possession. The appellate court accordingly concluded that the interference was proved, and therefore the plaintiff is entitled for a degree of injunction. The appeal was accordingly allowed. Sri Sidmalappa learned counsel for the appellant basically contended the suit itself was not maintainable, since one of the prayers in the suit was for an injunction to restrain the revenue authorities from making entries in the revenue documents. He submitted that in such a suit, which was not maintainable, the trial court could not have, the appellate court could not have decreed the suit. He also contended that the boundaries of the property were incorrect And having regard to this fact, it was wrong on the part of the appellate court to decree the suit. Admittedly, both the courts, on appreciation of the evidence, on the appreciation of the documentary evidence, have come to the conclusion that the plaintiffs had proved their lawful possession of the suited property. Both the courts have also taken note of the clear admission of the second defendant, DW1, who had also admitted the possession of the plaintiffs over the suited property. In the light of the concurrent finding of fact recorded by both the courts that the plaintiff was in possession, no substantial question of law as such to raise for consideration in this second appeal. Second appeal is accordingly dismissed. It is however made clear that if the right of the defendant over defendants 1 and 2 over their properties are denied or interfered with by the plaintiffs, they are at liberty to institute appropriate proceedings in respect of their properties. Since the appeal itself has been taken up on merits,
there is a delay ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
Commission of delay is allowed and the delay of 127 days is Rupesh. Rupesh ji. Rupesh. Next week. Shivaprakash.
This is second appeal for partition, and both the courts are concurrently dismissed. Now, on the other hand, sir, the partition suit under the relationship concerned, there is no dispute.
Not this bit I'm looking for.
Commentary
First file on 1, 2, yes. File is Bayamma and second one is Amma. So this Bayamma, Dr. Venkatarayappa, the plaintiff's husband. Venkatarayappa, the first defendant's husband and his wife and children. Now the present plaintiff before Malad is Dr. Venkatarayappa's wife Anamma and 2 daughters.
1 to 5 are the children, 1 to 4 are children of second son in Karnataka. And second wife children now have 5 to 6 are
5 to 8.
5 to 8. Whereas this genetic concept there is no this is happened in that. But the case they told is it's a giant family, and they are entitled for one time share. The defense taken by this defendant number 1 is that he was given to adoption to one Ramana. Number 1 was fine. And he has acquired properties. It is a self-owned properties.
He was the foster son of
He claims, but no document, no evidence, and denies. So, because two documents which we have produced, like he himself has produced the voter list and the wedding cards, all those things. Both the courts have overlooked and they have bypassed. So that it is a giant case, and we continue the giant family in this case. That both the courts are ignored and they are not, there is no observation, also there is no Lucius comments on these documents. And initially, say in the year 1960s, my propositor Nanapa was cultivating new lands, and there are Darkast lands. It's in the name of giant family, it was cultivation was there. Later, because this second son, Ventrapa was he is Indian and also only appears and was doing also. He assumed as the manager of the family. Though he is a junior member, he assumed. Dr. Ventrapa was only cultivating the lands towards the family. Those lands which are Darkast lands in cultivation, after death of my husband and death of Nanapa, and this person 90.
What did you produce to show that the property belonged to Narayana? Which property belonged to Narayana?
Now, one aspect is these Darkast land, there are 4 items. It was under cultivation of this giant family. At the time of grant of this Darkast land certificate, the Ventrapa, Indian person, he got in his name allotment to the Darkast. This aspect is very important. The court has not taken it out. Number 2, the giant families. Now, as it is, we made a possible assertion that we continue to be giant continues until we buy this suit. Now, also that proper this giant family has some properties. I have because after death of my propositor, his petition proceedings, there is no petition proceedings and there is no proceedings connected. It's only marks of the P8.
P8. That is understood item number?
Number 116. Next one. Item number 13. One item. And again,
ಇದರಲ್ಲಿ ಯಾರ ಹೆಸರು ಇದೆ ಐಟಮ್ ನಂಬರ್ 13 ಅಲ್ಲಿ?
ನನ್ನ ತಂದೆ ತಿಳ್ಕೊಂಡ್ಮೇಲೆ ವಾರ್ಸ್ತಾರ ಅಂತ
ಅದು ಮುಂಚೆ ಇದೆಯಾ ತೋರಿಸಿ, ಫಸ್ಟ್ ನಿಮ್ ತಂದೆ ಹೆಸರು ಇದೆಯಾ ತೋರಿಸಿರ್ತಾನೆ ನೀನು ಅದು ನೀವು ವಾರಿಸ್ತಾರ ಅಂತ ಹೇಳಕ್ಕಲ್ಲ. ಇದೇ ಮಾಡೋದಲ್ಲ ನೀವು.
I can understand what is possible because right from 1960 I know that it is application which has met and on what basis they have changed the information that I could not able to get it today. I can tell you number 1. So that it was in during the lifetime of my father's father-in-law.
So I'll take it that there is no document to show that any of the properties stood in the name of Narayana. No document is produced.
These are the recent documents which they have produced.
No document. ಇವಾಗ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಟ್ರೇಸ್ ಔಟ್ ಅಂದ್ರೆ ಏನ್ ಹೇಳಿ in both the courts you have not produced any document to show that none of the suit properties belong to the name of Narayana, correct? ILR ಇದ್ದೇ ಇತ್ತಲ್ಲ, ಅದ್ರಲ್ಲಿ ಯಾವ್ದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ನೀವು ಟು ಶೋ.
ಅಂದ್ರೆ ಅಲ್ಲಿನ ಡಾಕ್ಟರ್ ಇವತ್ತು ಡಾಕ್ಯುಮೆಂಟ್ ಆಗಿದೆ. We have given all those voter list and this ration card and other documents also.
How many documents did you produce, Mr. Shivaprakash? ಇರೋದು P1 to P20, ಇನ್ನೊಂದು P21 ಹೌಸ್ ಅಸೆಸ್ಮೆಂಟ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್. ಇದು ಬಿಟ್ರೆ ಬೇರೆ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ಲಿಲ್ಲ. How will the court know whether this property belong to Narayanappa? What can you do?
Let us go forget about all those documents. Is admitted fact where a cross-examination unable to admitted. Yes, our family never partitioned. That's the one that point also. And second thing is, there are properties of our ancestors which is admission of dependent inside. Those things has to be taken. Then the lower court will take the cross-examination one comes ready.
Ramchandra Reddy is the different number.
One. Our money was open the Mexico.
Yaro.
Is the Maga.
Different. D3 na. Ramchandra na. D3 na.
DW1.
Is the D3. D3.
Yeah. Okay. ನಾನು ಇಲ್ಲಿ ಇದ್ದಿದ್ದು ನಾವು
Yes.
The writings and information hopefully will separate the guidelines and properties left by our grandfather. In fact, myself and second can have also documented and studied surveillance on sites. But now I am taking an time to straight to the class examination. It is 8/6/2011. The first time of money, 8/6/2011. Class examination of 8/6/2011. Marking of documents at the next page.
Yes.
Narayanappa ಮತ್ತು ಪಿಳ್ಳಪ್ಪ ಯಾವಾಗ ವಿಭಾಗದಲ್ಲಿ
ಯಾರು who's Narayanappa and who's Pillappa? What's your father?
Our grandfather is father of Dr. Venkappa and Venkappa. ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಪಿಳ್ಳಪ್ಪ ಮತ್ತು ರಾಮಣ್ಣ 100 ವರ್ಷಗಳಿಂದ ವಿಭಾಗ ಅವರ ಸಂಬಂಧ ನಾವು ದಾಖಲೆ ಹಾಜರು ಮಾಡಿಲ್ಲ. ನಿಮ್ಮ ದೊಡ್ಡಪ್ಪ ಮತ್ತು ನಿಮ್ಮ ತಂದೆ ಆಸ್ತಿಯನ್ನು ವಿಭಾಗ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ. ಇದರ ನಮ್ಮ ಆಸ್ತಿಗೆ ಸಂಬಂಧ ಇಲ್ಲ ನುಡಿಯುತ್ತಾರೆ. ನನ್ನ ತಂದೆ ಮತ್ತು ನನ್ನ ದೊಡ್ಡಪ್ಪ ವಿಭಾಗ ಆಗಿದ್ದಾರೆ ಎನ್ನುವ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. My father, that's Venkappa and
He does not know about the partition between your father and his uncle and his brother.
That's Venkappa and this Venkappa's father is Narayanappa.
And his brother is Pillappa. The question is Narayanappa ಮತ್ತು Pillappa ಯಾವಾಗ ವಿಭಾಗ ಮಾಡ್ತಾರೆ ಅಂದ್ರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. I don't know between of the partition between my father and my uncle.
Then partition ಆಗಿಲ್ಲ ಆಗಿದೆ ಅನ್ನೋದು ಬೇರೆ ವಿಚಾರ. ಅದನ್ನ ನಾವು ಪ್ರೂವ್ ಮಾಡಬೇಕು. ನಾರಾಯಣಪ್ಪ ಬಂದಿರೋದು ಬಂದು ನಾವು
ಅದನ್ನ ತೋರಿಸಿ ಅಂತ ಅದನ್ನ ಹೇಳ್ತಿರೋದು. Whereas he admitted that some of the suit properties had fallen to the share of Narayanappa. The matter ends. Where is he admitted?
ನನ್ನ ತಂದೆ ಮತ್ತು ನನ್ನ ದೊಡ್ಡಪ್ಪ ಹಾಕಿದ್ದಾರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನನ್ನ ತಂದೆ 1 ವರ್ಷದ ಮಗುವಿನ ರಾಮನನ್ನು ಸಾಕಿಕೊಂಡಿದ್ದರು.
ನನ್ನ ತಂದೆ 1 ವರ್ಷದ ಮಗುವಾಗಿದ್ದಾಗ ರಾಮಣ್ಣನು
ಸಾಕಿಕೊಂಡಿದ್ದನು. ಸದರಿ ವಿಷಯಗಳನ್ನು ನನ್ನ ತಂದೆ ನನ್ನ ಅಜ್ಜಿ ನನಗೆ ಹೇಳುತ್ತಿದ್ದರು. In the return statement, first paragraph is the return statement.
He is a son of this Venkatrayappa. No, DW, yeah, deposition that you are reading. That is D3. He is the son of this second son Venkatrayappa. He says ನನ್ನ ತಂದೆ 1 ವರ್ಷ ಮಗು ಇದ್ದಾಗ ರಾಮಣ್ಣನು ಸಾಕಿಕೊಂಡಿದ್ದನು. ಸದರಿ ವಿಷಯಗಳನ್ನು ನನ್ನ ತಂದೆ ನನ್ನ ಅಜ್ಜಿ ನನಗೆ ಹೇಳುತ್ತಿದ್ದರು. ರಾಮಣ್ಣನು ಸಾಕಿಕೊಂಡಿದ್ದ ಬಗ್ಗೆ ಅದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ ಶಿವಪ್ರಕಾಶ್. ನಿಮ್ ಕೇಸ್ ಸಿಂಪಲ್. ನಾರಾಯಣಪ್ಪನ ಆಸ್ತಿ ಇದು ಅಂತ, ಇದು ಪಿತರಾರ್ಜಿತ ಆಸ್ತಿ ಅಂತ. ನಾರಾಯಣಪ್ಪನ ಆಸ್ತಿ ಪಿತರಾರ್ಜಿತ ಆಸ್ತಿ ಅಂತ ತೋರ್ಸಕ್ ದಾಖಲಾತಿ ತೋರಿಸಿ ಸಾಕು. ಇದೆಲ್ಲ ಯಾಕೆ ಸುತ್ತಮುತ್ತ ಬಳಸಿ ಎಲ್ಲೆಲ್ಲ ಹೋಗೋದು? ಟ್ರೇಸ್ ಔಟ್ ಹೆಂಗ್ ಮಾಡ್ತೀರಾ ಶಿವಪ್ರಕಾಶ್? ಇರ್ಬೋದು, ಅಲ್ಲಿ ಎಲ್ಲ ಇರುತ್ತೆ. ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ಲ ಅಷ್ಟೇ. ಕೆನ್ ಬಿ ವೇಟ್? I'm not straight away jumping to conclusion. You had suit was of the year 2006. We are in 2022. For how many years should the court wait for you to secure the documents and furnish it? If you don't produce it, even after 16 years, you want the court to once again give you a chance to produce it, a document which you were aware was to be produced in order to establish your right? If you choose not to do it, Order 41/27 is not a matter of right, especially in second appeal. That is why you are given a chance in the trial court and also in the appellate court. In both the courts, you did not take this opportunity. Now in second appeal, after suffering a finding at both the courts,
and my uncle and solution is now in the court below, the document which are published in the advocate and the appellate before the lower court. Those documents, when I heard these persons before this second appeal, and the fact all those documents are intact in the file.
ಏನ್ ಮಾಡಕ್ಕೆ?
You should notice my lord has said for the lapse advocate, the party should not suffer. It's my word.
It is very easy for us to blame the lawyers now. ಗೆದ್ದಿದ್ರೆ ತುಂಬಾ ಒಳ್ಳೆ ಕೇಸ್ ಇತ್ತು, ಲಾಯರ್ ಚೆನ್ನಾಗಿ ಮಾಡದ ಅಂತ. ಗೆದ್ರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೆ, ಅವನ್ ಮಾಡ್ಲಿಲ್ಲ, ಆಗೋಯ್ತಲ್ಲ. That is the accusation that you made. Bail ಕೊಟ್ಟಿದ್ರಿ ಏನಿಲ್ಲ ಬಿಡಿ, ಆಗೋಯ್ತು. ಎಲ್ಲಕ್ಕೆ ಜನರಲೈಸ್ ಮಾಡ್ಬಿಡೋದು. ಈ ಕೇಸಲ್ಲಿ ಏನಿಲ್ಲ. He has 13 sale hits in his favor.
Copy is also served to my lapse ಆಗಿದೆ. ಹಾಗಾಗಿ ನಾವು
irreparable lapses ಅದೇ ಬಂದಿ ಪ್ರಾಬ್ಲಮ್.
ನಾವು
ಇಲ್ಲ, ಹೋದ್ ಸಲ ಕೇಳಿದೆ, ಒಂದು ಪ್ರಾಪರ್ಟಿ ನಾರಾಯಣ ತೋರಿಸಿ, there's something. Not even one document is the name of your grandfather.
My grandfather is there.
Elli?
Now, to show that we are in kind family, put documents which I have produced.
I can't take it across like that. ಅಲ್ಲ ಅದು ನೀವು ಕೊಡಿಬೇಕಾರೆ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು?
ಇದು ಕೇಸ್ ಹಾಕೋರು ನಾವೆಲ್ಲ ಒಂದು ರೂಮ್ ನಲ್ಲಿ ಒಂದು ಮನೆ ಇರ್ತಂತ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಅಂತ ತೋರಿಸೋದಕ್ಕೆ ವೋಟರ್ಸ್ ಲಿಸ್ಟ್ ಟೈಪ್ ಫಾರ್ 1960s. ಒಂದು ಯೂನಿಟ್ ಅಂತ ಒಂದು ಮೀಟರ್. ಆಮೇಲೆ ಮದ್ವೆಗಳು ಮಾಡಿದಲ್ಲಿ ಎಲ್ಲಾರು ದೊಡ್ಡ ವೆಂಕಟಪ್ಪ ಎನ್ ವೆಂಕಟಪ್ಪ ಅಂತ ಸ್ಟಾರ್ಟ್ಸ್ ಆಫ್ 1960 to 1995 ಒಂದು ಕುಟುಂಬದಲ್ಲಿ ಆತ್ಮ ಹೆಸರು ಹಾಕೊಂಡು ಮಾಡಿದ್ರು. These are the documents which I have presented. Second thing is these are the documents which we can and even the Honorable High Court. These documents are on record. The Honorable High Court has not put it in my name.
Now on record ittu andre on what basis are you saying it was on record? On what basis are you saying it was on record? Trial court has not looked into it.
Trial court alli ide. What are
ಇಲ್ಲಿ ಎಲ್ಲಿದೆ? ಎಕ್ಸಿಬಿಟ್ ಮಾರ್ಕ್ ಆಗಿಲ್ಲ.
ಒಂದು ಶೀಟ್ ಆಗಿ ಇನ್ನೊಂದು ಶೀಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದರಿಂದ ಇದು ಎಕ್ಸಿಬಿಟ್
ನೀವು ಮಾಡಿದ ಬರೀ 21 ಡಾಕ್ಯುಮೆಂಟ್.
ಎಕ್ಸಿಬಿಟ್ B42
ರೇಷನ್ ಕಾರ್ಡ್.
ಅದ್ರ ಮೇಲೆ ಏನು ಕಮೆಂಟ್ ಇಲ್ಲ. ರೇಷನ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ನಮ್ದೆಲ್ಲ
ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಬಿಟ್ಬಿಡಿ ಪ್ರಕಾಶ್. ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್
ಏನು ಕಳ್ಸ್ಕೊಟ್ಟಿದ್ದಾರೆ ಯಜಮಾನ ಅದನ್ನೇ ಗಮನ ತರೋಣ.
How does it establish the property belong to your father?
I have placed all the documents and I'm a trial court and I'm a personal court. Totally for this document.
ನಿಮ್ಮ ಹತ್ರ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ going to establish your case.
ನಾವೆಲ್ಲ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ is a plaintiff or dependent. Plaintiff or dependent. One way plaintiff is also the dependent also the plaintiff. If he is a stranger, then what my lawyer says is correct.
Over a period of time, last time also I told you, from 57 I think till 60s, he has consistently purchased the properties. We will accept your argument that they were purchased out of the joint family nucleus. We have to establish joint family nucleus first. Without that, there is nothing.
Even for the sake of argument, I agree to establish. Now, is that a person who has claimed himself as a separate property to show that he had such a source of income and it is the source.
The burden is upon you to first show that it was joint family property. No. First pendulum ನಿಮ್ ಕಡೆ ತಿರುಗುತ್ತೆ. ನೀವು ತೋರಿಸ್ಬೇಕು ಇದು ಒಟ್ಟು ಕುಟುಂಬದ್ದು ನಾವು ಆಸ್ತಿ, ಇದು ಇಂಥ ದಿನ ನಮ್ ತಾತ ಕೊಂಡ್ಕೊಂಡ, ನಮ್ ತಂದೆ ಕೊಂಡ್ಕೊಂಡ, ನಾವೆಲ್ಲ ಒಟ್ಟಿಗೆ ಸಾಗುವಳಿ ಮಾಡ್ತಿದ್ವಿ. ಏನು ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಸ್ಟಾರ್ಟ್ ಫ್ರಮ್ ದ ಡೇ ಪರ್ಚೇಸ್ ದ ಪ್ರಾಪರ್ಟಿ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಮೇಲೆ ಬರೋಣ. ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲಿದೆ?
Class examination where I was reading AW1 after the reading. Joint family ನಲ್ಲಿ ನಾವು ಒಂದೇ ಸತಿ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ನನ್ನ ತಂದೆ 1 ವರ್ಷದ ಮಗು ಇದ್ದಾಗ ರಾಮನನ್ನು ಸಾಕಿಕೊಂಡಿದ್ದನು. ಅದು ಸದರಿ ವಿಷಯವನ್ನು ನನ್ನ ತಂದೆ ನನ್ನ ಅಜ್ಜಿ ನನಗೆ ಹೇಳುತ್ತಿದ್ದರು. If he is adopted son, then why is the question of his father and his grandmother saying this? ರಾಮನ ಸಾಕಿಕೊಂಡದ ಬಗ್ಗೆ ದಾಖಲೆ ಇಲ್ಲ. ರಾಮಣ್ಣನ ನಮ್ಮ ಊರಿನವರು. ರಾಮಣ್ಣನಿಗೆ 3 ಮಕ್ಕಳು ಇರೋದು ನಿಜ. ಅದರಲ್ಲಿ 2 ಹೆಣ್ಣು 1 ಗಂಡು. ರಾಮಣ್ಣನ ಮಗ ವೆಂಕಟಪ್ಪನಿಗೆ ಮಕ್ಕಳಿಲ್ಲ. ರಾಮಣ್ಣನ ಆಸ್ತಿ ವೆಂಕಟಪ್ಪನಿಗೆ ಬಂದಿತ್ತು. ಈಗ ವೆಂಕಟಪ್ಪನ ಮನೆಯಲ್ಲಿ ನನ್ನ ತಾಯಿಯ ತಮ್ಮನ ಮಗನ ಕೃಷ್ಣಪ್ಪ ಇದ್ದಾರೆ. ಮತ್ತೆ ಸಾಕ್ಷಿಕೊಂಡಿದ್ದಾರೆ. ನಮ್ಮ ತಾಯಿಯ ಚಿಕ್ಕಪ್ಪನ ಮಗ ಕೃಷ್ಣಪ್ಪ ಇದ್ದಾರೆ. ಕೃಷ್ಣಪ್ಪ ಮಳ್ಳೂರಮ್ಮನ ಮಗ ಎಂದರೆ ನಿಜ. ಮಳ್ಳೂರಮ್ಮ ಅಕ್ಕ ತಂಗಿರಿ ಎಂದರೆ ನಿಜ. ಅಕ್ಕಯ್ಯಮ್ಮನ ಮಗಳೇ ನನ್ನ ತಾಯಿ ಕೆಂಪಮ್ಮ ಎಂದರೆ ನಿಜ. ರಾಮಣ್ಣ ಮತ್ತು ವೆಂಕಟಪ್ಪನ ಆಸ್ತಿ ಕೃಷ್ಣಪ್ಪನಿಗೆ ಬರೆದು ಕೊಟ್ಟು ಆತನ ಅನುಮೋದನೆ ಇದ್ದಾರೆ. ರಾಮಣ್ಣ's biological son ಕೃಷ್ಣಪ್ಪ ಅಂದರೆ ನಿಜ. ರಾಮಣ್ಣನು ನನ್ನ ತಂದೆಗೆ ಆಸ್ತಿಯನ್ನು ಬರೆದುಕೊಟ್ಟಿಲ್ಲ. ರಾಮಣ್ಣನು ನನ್ನ ತಂದೆಯನ್ನು ಸಾಕಿಕೊಂಡಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಮ್ಮ ಕುಟುಂಬದಲ್ಲಿ ನನ್ನ ತಂದೆ ಯಜಮಾನಿಕೆಯನ್ನು ಮಾಡುತ್ತಿದ್ದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಬಾಡಿ ಪ್ರತಿವಾದ ಒಟ್ಟು ಕುಟುಂಬದಲ್ಲಿದ್ದು ನನ್ನ ಬಳಿ ಭಾಗವನ್ನು ಕೇಳಿದರೂ ನಾನು ಕೊಡಲಿಲ್ಲ ಎಂದು ಸೂಚಿಸುವುದು ಸರಿಯಲ್ಲ. ದೊಡ್ಡ ಹೆಂಡತಿಯ 1ನೇ ವಾದ ಎಂದರೆ 2ನೇ ಹೆಂಡತಿಯನ್ನು ಸಾಕ್ಷಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲಾ ಕುಟುಂಬದ ಆಸ್ತಿ ನನ್ನ ತಂದೆ ಹೆಸರಲ್ಲಿ ಇದೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ತಂದೆಗೆ ಯಾವುದೇ ಸ್ವಾಯತ್ತ ಇಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ದೊಡ್ಡಪ್ಪನಾದ ದೊಡ್ಡ ವೆಂಕಟಪ್ಪನಿಗೆ ಗಂಡು ಮಕ್ಕಳಿಲ್ಲ, ಇಬ್ಬರು ಹೆಣ್ಣು ಮಕ್ಕಳು ಮಾತ್ರ ಇದ್ದಾರೆ ಎಂದು ನಿಜ. ಹೆಣ್ಣು ಮಕ್ಕಳಿಗೆ ಭಾಗ ಕೊಡಬಾರದು ಉದ್ದೇಶದಿಂದ ಎಲ್ಲಾ ಆಸ್ತಿಗಳು ನನ್ನ ತಂದೆಯ ಸ್ವಾಯತ್ತ ಆಸ್ತಿಗಳನ್ನು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಮತ್ತು ಪ್ರಾಣದ ವರಮಾನದಿಂದ ಎಷ್ಟು ವರಮಾನ ಇತ್ತು ತೋರಿಸಲು ನನ್ನ ತಂದೆ ಒಂದು ಪುಸ್ತಕ ಇಟ್ಟುಕೊಂಡಿದ್ದಾರೆ. ಅದನ್ನು ನಾನು ಹಾಜರು ಮಾಡಲು ಸಾಧ್ಯವಿಲ್ಲ. That these are business we are doing in the, and this is the income I did, I purchased these into the companies. He has produced, then I don't straight away it will not come to me. Now, he says that in those ನನ್ನ ತಂದೆ ಒಂದು ಪುಸ್ತಕ ಇಟ್ಟುಕೊಂಡಿದ್ದಾರೆ, ಅದನ್ನು ನಾನು ಹಾಜರು ಮಾಡಲು ಸಾಧ್ಯವಿಲ್ಲ. ಈಗ ನಾನು ಚಿಕ್ಕ ಹುಡುಗನಾಗಿದ್ದೆ ಎಂದು ಸಾಕ್ಷಿ ನೀಡಿದ್ದಾರೆ. ಒಟ್ಟು ಕುಟುಂಬದ ಆಸ್ತಿಯಲ್ಲಿ ಬಂದ ವರಮಾನದಿಂದ ನನ್ನ ತಂದೆ ಆಸ್ತಿಯನ್ನು ಸಂಪಾದನೆ ಮಾಡಿದ್ದಾರೆ ಸರಿಯಲ್ಲ.
So this is your specifically ಒಟ್ಟು ಕುಟುಂಬದ ಬಂದಿರೋ ಆದಾಯದ ಮೇಲೆ ಈ ಆಸ್ತಿಗಳು ಸಂಪಾದನೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ. This is your suggestion. This is your cross examination. So please establish prima facie that the family owns certain properties out of which you had adequate income to purchase these 13 or 30 properties. If you fail there, you fail.
What is the joint family? What is that?
I am going by your assertion that these properties, suit properties were purchased out of the joint family nucleus. So until you establish joint family nucleus, according to me, you have a very, very difficult case. Madi, from the documents that are available on record. We can't wait for that.
When such document and when such detail is trust, by acts of one person, we cannot suffer injustice. Because when they are together, when my father, when this Dodwankappa and Invankappa, now they are no more. These children, they didn't throw me out. They are in one room, in one house. Now merely because the document or the sales tax is there, they cannot throw me out. There is
a finding of fact, Mr. Shiprakash. I can't in second appeal reappreciate the evidence when there is no evidence on your behalf at all. Anything else?
You can accept it.
Mr. I take it record enough. What is the reason given by you for non-production?
This petition and other things what right from 1960, the name of Narnappa. What has happened?
This virtually kills your case. So your documents were available with you and you gave it to the council. Therefore, you were perfectly aware as to what are the documents that were to be produced in order to succeed in your case. If this is the reason that you give, it will kill your case. Affidavit
what amount of evidence and what amount awareness these documents, whatever advocate said, she believes and she was there. Only
I'll consider.
And the mutation proceedings.
I'll consider. These are the only documents that you are now produced. These are the only documents that you are now producing. But order 41 rule 27 does not give you this right to come and produce them whenever and wherever you want.
What is really what was from the 7 also, I can guess one or two things and also say that if really accepts this court for recurring justice, then court has to look into it. So the apex court in I can place it.
Judgment reserved.
ಎಲಿಜಿಬಲ್ ಆಗಿಲ್ಲ. ಅದಾಕ್ಟ್ ಸಬ್ಮಿಟ್ ಆಗಿದೆ ನೋಡಿ ಆಮೇಲೆ ಅಲಾಟ್ it has happened repeatedly. I'm requesting and I can place it. My lord is on one point that giant family in Karnataka. Those mutations are those things which is blocked, it is not legible. I can place it on that. If I am wrong, then my lord will take a decision. Tomorrow.
ಮಾಡಿ ನಿಮ್ಗೆ ಅವಸರ ಇದೆ, ನಾನು ನೀವು ಜಡ್ಜ್ಮೆಂಟ್ ರಿಸರ್ವ್ ಮಾಡ್ಕೊಳ್ತೀನಿ. ನಾನು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದ್ದೀನಿ. Tomorrow. Finally, Wednesday. I spent almost 2 hours for your case. ಮೊನ್ನೆ 1 ಗಂಟೆ, ಇವತ್ತು 1 ಗಂಟೆ. ಅದೇ ಕ್ವೆಶ್ಚನ್ ನಾನು ಕೇಳ್ತೇನೆ, ನೀವು ಅದೇ ಆನ್ಸರ್ ಹೇಳ್ತಾ ಇಲ್ಲ. ನಾನೇನು ನಿಮ್ಗೇನ್ ಸಡನ್ ಸರ್ಪ್ರೈಸ್ ಮಾಡ್ಲಿಲ್ಲ. ಮೊನ್ನೆಯಿಂದ ಒಂದೇ ಕ್ವೆಶ್ಚನ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಆ ಕ್ವೆಶ್ಚನ್ ನೀವು ಆನ್ಸರ್ ಹೇಳಲ್ಲ. ಫಸ್ಟ್ ನಿಮ್ಮನ್ನ ಕನ್ಸಲ್ಟ್ ಮಾಡಿ ದಾವ ಹಾಕಿದ್ರೆ ಸರಿ ಹೋಗ್ತಿತ್ತು. ನಿಮ್ಗೆ ಕನ್ಸಲ್ಟ್ ಮಾಡಿಲ್ಲ, ಅದಕ್ಕೆ ತೊಂದರೆ ಆಗ್ತದೆ. Finally, Wednesday.
Your lordship's kind permission, my lord.
1 minute. 27. I have a bench in the afternoon.
Tomorrow. Right, claim that as economic or doing management in other sources maintain as well. Right, for both of us have very nice.
Next week.
My lord, in the third list, my lord, 3 matters are there, my lord, repeatedly listing.
30th matter, 30th.
13, 18, 21.
30.
13, 18, 21, Lord.
1 minute. List number 2. Ready na? Urgency ಇದೆಯಲ್ಲ, next week ಬರಲ್ಲ.
Serial number 15.
ಹೇಳಿ. Mentioning.
Your lordship, kind permission, my lord. Serial number
3ನೇ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 18, 13, 18, 21. ತಾವು ಮಧ್ಯಾಹ್ನ ಇರ್ತೀರಿ ಅಂದ್ರೆ ನಾನು ರೆಡಿ ಇದ್ದೀನಿ ಸ್ವಾಮಿ.
ಮಧ್ಯಾಹ್ನ ಬೆಂಚ್ ಇದೆ ನಂಗೆ.
ಅಲ್ಲ, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 36, my lord.
3ನೇ ಲಿಸ್ಟ್ ನಂದು 13, 18, 21.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 36 in second list.
18, 21.
ಮಧ್ಯಾಹ್ನ ಬೆಂಚ್ ಇದೆ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಅಷ್ಟೇ.
ಡೇಟ್ ತಾವು ಮೆನ್ಷನ್ ಒಂದು ಡೇಟ್ ಹೇಳ್ಬಿಟ್ರೆ ಒಳ್ಳೇದು.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ.
List number 2, serial number 15. Serial number list number 2, your lordship can see serial number 36. In the last occasion, your lordship has had some time. It is a simple matter, my lord, because 24th or 25th, my lord.
24th.
Much obliged.
Serial number 55. Serial number 15.
One at a time. Shankar.
Serial number 55. The parties not were directed to be present before the court, not in order to not report compromise. And all the parties not waiting near the gate. Not if the court permits, they will be. The police will not inform them that unless there is a direction by the court, will not be allowed.
All right, I'll come at 2:15 then for this.
Please.
2:15.
Lord, serial number 2 in the list number 3, my lord.
Because there are as many as 35 persons not may request the court not to inform the concerned.
Yes, I've told them.
Lord,
Serial number 14, my lord.
List number 2, serial number 15, my lord.
One at a time. Serial number 14 here.
Serial number 14. List number 2, my lord.
It's adjourned.
My lord, it is very urgent, my lord. This
case ನಾವೇನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? Can I wait for you? Next week.
Serial number 56, my lord. List number 2.
My lord, serial number 35, my lords, can it be had after 3 weeks? There's a report by the trial court. I need to obtain certified copy. This is a case of 2 rival impleading applicants. And certified copy of the there is a serial number 35 in list 2, my lords.
3 weeks. Three weeks after 3 weeks.
Let's.
Next week.
Serial number
15,
Monday.
Serial number 56.
Serial number
List number 2.
Automatic.
List number 2, serial number 15, my lord. That I am told that it's passed over. Yes, I was held up in some other court, my lord, that I could not represent.
Matter?
15, my lord, that Ashwataya and that I wanted to present that. Next week, 2 days are
next week.
Please.
Lord, serial number 2 in list number 3, my lord.
Yes.
Lord, the respondent counsel has filed a memo saying the respondent number 2A is dead. I have filed an application to consider respondent number 2B to 2E as LRs of 2A. So the application may be listed along with the appeal, my lord.
Stated in application is filed to create
R2 is dead, to consider R2A is dead, to consider R2B to R2E as legal representatives of R2A.
R2E as the LRs of the deceased R2A. Office to put up the said application. Yes.
Lord, kindly have it day after tomorrow, my lord. I'd like to argue the matter. I'm ready to argue this matter. 2006 matter, my lord. Day after tomorrow, my lord.
Next week.
Lord, next week andre idu nan kaitane idini list the second matter and the list will bartide, but the first matter gets over and then the second matter is not reaching. Kindly have it day after tomorrow in the second list, my lord.
Same problem. Even day after tomorrow it will be the same. I'm not able to finish admission matters. And I have a bench. It would have been taken up today, but there's a bench.
Day after tomorrow, I'll take my chance, my lord. Let it come in the list, my lord.
Yes.
Serial number 56, list number 2, my lord.
Marad.
Serial number 56, my lord.
Yes.
List 2, my lord.
Yes.
Interim order may be extended, my lord.
Yes. Anybody else?
Serial number 19, my lord. Kindly with 1 week press some time.
Prakash.
Serial number 19, my lord. Case was passed over. Admission and pass over. 19, sorry. Serial number 2.
Petition center goitala. 19 na 9
19, sorry, 19.
Sidmalappa and Satish Chandra.
Gururaj Sangur anta case or pass over agide. Admission and hearing.
Serial number ಹೇಳ್ಬೇಕಂದ್ರೆ.
Yes.
ಯಾವ serial number correct ಆಗಿ ಹೇಳಿದ್ರೆ?
Yes.
44 in list number 2, my lord.
40.
Could it be, my lord, day after tomorrow, my lord? I filed one memo along with our submission.
Next week ಬರುತ್ತೆ ಬಿಡಿ. Everything will be repeated next Monday.
Lord, I can Tuesday, my lord, 38, my lord. Monday inconvenient. 38, Tuesday, my lord, first.
Partial complaints ಆಗಿದೆಯಾ ಅಂತ. Finally 1 week time. Bench next week, Monday.
My lord, serial number 38. I'm sorry, my lord.
ನಾನೇನ್ ಮಾರ್ಚ್ ಇಂದ ಇರಲ್ಲ ಸರ್ ನಾನು for hearing the first week of April.
Number 52 list 2 March.
Third week of March only. Post for hearing in the second week of March.
Serial number 42, my lord.
Lord, serial number 38.
1 minute, 42.
Sorry, ma'am.
I have permission to genealogical. I have one.
I1 for permission to produce inventory is granted.
Process.
48.
The state has been done.
Serial number 48. In list number 2. Early hearing may be ordered. Serial number 48, list number 2.
He was different more in the trial court. In the regular appeal, he was not made a party. Suit for day after tomorrow.
Your Honor, serial number 31, my lord. Injunction and declaration suit. Today has to proceed the court memo. Today has to inconvenience. Day after tomorrow, my lord.
Next week.
38 from 1ನೇ ತಾರೀಕಿಗೆ ಸರ್.
List 2 minutes. Number 2. Serial number 52.
52.
I have filed a memo, my lord, affidavit on Saturday. Is for appellate. Land was allotted to CRPF. There was issue of boundary. Now it has been settled. Issue does not serve for consideration because there is a huge extent of land in which portion of the land was allotted to CRPF. It went to approved Supreme Court. One of the brother of the respondent.
Dispose does not survive.
Does not serve because our boundary has been fixed.
Counsel for the appellate has filed an affidavit in which it is stated that the suit itself does not survive for consideration, and as a consequence, the second appeal has been rendered infructuous. Accepting the said affidavit, this regular second appeal is disposed of.
There is one more connected matter, minutes. In that slight different issue is there, but same holds good. What I request is the other side also has been served in this matter, minutes. In this matter, nobody is there. Otherwise, can it be taken up? Day after tomorrow, they will also appear in the matter. Some
2.1.
50.1. This also can be taken up on day after tomorrow because in the orders list so that they can appear and if they have got anything to say, can they say?
No, if you are saying it does not serve, I'll record your statement and close it.
That's all fine. I'll serve the copy through email to them. That may be recorded.
Same affidavit.
Same affidavit in the first matter. Second matter are not filed in affidavit. Issue is one and the same. They explain that in that the others
submits second matter that this second appeal is also rendered infructuous. In view for the very same reason stated.
There are some other connected suits are there in that second matter. That will take out day after tomorrow. Will take some other incident. Day after tomorrow. Second matter. First matter.
Lord, serial number 38. Really day after tomorrow. बुधवार के समय.
Next week. Delay idea. Without counsel is permitted to take out and summons on respondents who are represented by their counsel in the executing court. ಯಾರೋ ಒಬ್ರು ತೀರೋಗಿದಾರಂತೆ. CH-19 and RA ಅಂತಾರೆ.
With permission 38 my lord.
Other matters are there.
ಪೂರ್ತಿ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕಾ ನಿಂದು?
My lord, with permission, my lord. Serial number 38, kindly day of tomorrow, my lord, 23 ke swami. Agency is there. More than to some.
The next week ಬರುತ್ತೆ ಬಿಡಿ.
Contesting respondent number 1 is duly served swami. ಅವರೇ ಮೇನ್ ಇರೋದು ಸ್ವಾಮಿ.
Next week ಬರುತ್ತೆ.
1ನೇ ತಾರೀಕು ಬೇಡಿ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಫಸ್ಟ್ ನೀವು ಸರ್ವ್ ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ ಮೂವ್ ಮಾಡಿ. ನಂಬರ್
1ನೇ ತಾರೀಕಿಗೆ
1 week finally.
Court officer. Court officer.
Court officer.
Serial number 25 ಆಗಿದೆ ನೋಡಿ.
Court officer. Serial number 56 interim order extend ಆಗಿದೆಯಲ್ಲ ಸರ್?
ಆಯ್ತು. Court officer, serial number 25 second list.
Court officer 38 ಏನ್ ಮಾಡೋದು ಸರ್? 1ನೇ ತಾರೀಕು ಡೇಟ್ ಕೊಟ್ರ ಅಥವಾ ಏನ್ ಮಾಡೋದು ಸರ್?
Court officer 25, serial number 25. Court officer, serial number 25. Number second.
Court officer.
Court officer. Officer ಇಲ್ಲ. Hello.
Court officer, sir.
Court officer.
ಸರ್ ಹೇಳಿ ಸರ್.
Serial number 25 ಏನು ಅರ್ಚನೆ ಆಗಿದೆ ನೋಡಿ. Serial number 25 ಗುರುರಾಜ ಸಂಗೂರ್.
Court officer.
25 next week ಸರ್.
much obliged.
38 1ನೇ ತಾರೀಕು ಹೇಳಿದೆ ಡೇಟ್ ಕೊಟ್ರು ಮೇಡಮ್ 1ನೇ ತಾರೀಕು.
ಯಾವುದು?
38 ಮೇಡಮ್.
Court officer.
ಇಲ್ಲ
Serial number 56 interim order.
ಕೊಟ್ಟಿಲ್ಲ ಅದು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಸರ್ ಅದೆಲ್ಲ.
Court officer. Serial number 56 extend ಆಗಿದೆ, interim order extend ಆಗಿದೆಯಾ ನೋಡಿ. 56.
ಶಂಕರ್ ರೆಡ್ಡಿ.
Second list.
ಸರ್ ಕೇಳಿದೆ ಇವಾಗ.
ಸರ್ ಶಂಕರ್ ರೆಡ್ಡಿ.
ರೂಪೇಶ್.
ಸರ್ ಹೇಳಿ ಸರ್. ಸರ್ ಶಂಕರ್ ರೆಡ್ಡಿ ಸರ್. ಎಲ್ಲಿದ್ದಾರೆ ಸರ್? ಯಾವ ಗೇಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ?
ಸರ್ ಈ ಕಡೆ
ಬೈಸ್ಕೊಂಡೆ ಸಂಗೂರ್ ಅಂತ ಸಾಹೇಬ್ರ ಹತ್ರ.
ಕ್ಯಾಂಟೀನ್ ಕಡೆ ಇದು ಗೇಟ್ 5.
ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು ತಾನೆ. ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 25 ತಾನೆ.
ಸರ್ ಹೇಳ್ತೀನಿ ರೀ.
ಹಲೋ. ಸೀರಿಯಲ್ ನಂಬರ್ 25 ತಾನೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 25 ಆ? ಯಾರ್ಯಾರ ಹೆಸರೆಲ್ಲ ಹಾಕ್ಬಿಡ್ತಾರೆ, ನಮ್ ತರ ತಿಂತಾರೆ.
Court officer, serial number 56 interim order extend ಆಗಿದೆಯಾ? Court officer. Court officer. Court officer. Court officer, interim order extend ಆಗಿದೆಯಾ ನೋಡಿ, serial number 56 second list. Hello. Hello. Court officer. Court officer. Court officer, serial number 56 list number 2 ದಲ್ಲಿ interim order extend ಆಗಿದೆಯಾ ನೋಡಿ. Hello. Court officer.
ಕಾಪಿ ತಗೊಂಡು ಹೋಗ್ದಲ್ಲ ಕೆಳಗಡೆ ಯಾವ್ದಾರ ಫೋಲ್ಡ್ ಅಲ್ಲಿ ಖಾಲಿದೆ.
Court officer. Hello. Hello. Court officer, serial number 56 list number 2 ದಲ್ಲಿ interim order extend ಆಗಿದೆಯಾ ನೋಡಿ. Court officer. ಅಲ್ಲ, serial number 2 ದಲ್ಲಿ Court officer. Court officer. Sir, list number 2 ದಲ್ಲಿ serial number 56 interim order extend ಆಗಿದೆಯಾ? Serial number 56 list number 2.
Extend ಆಗಿದೆ sir.
Extend, yeah, date ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್? ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್ ಅದರಲ್ಲಿ? Court officer. ಏನು ಕೇಳುತ್ತಾನೆ ಇಲ್ಲ. Court officer. Court officer. Hello. Hello. Court officer. ಅದೇ ಅವ್ರು ಮಾತಾಡೋದು ಕೇಳ್ತಾ ಇಲ್ಲ, ನಾನು ಮಾತಾಡೋದು ಅವ್ರಿಗೆ ಕೇಳುತ್ತೋ ಇಲ್ಲೋ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಅದು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆಯಾ ಇಲ್ವಾ ಅಂತ ಗೊತ್ತಾಗಿಲ್ಲ. ಅದೇ ಯಾರು ಮಾತಾಡಿದ್ರು ಅವ್ರು ಮಾತಾಡೋದು ಕ್ಲಿಯರ್ ಆಗಿ ಬರಲಿಲ್ಲ, ಅದಕ್ಕಾಗಿ ಇದಾರು ಇಲ್ಲ. ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್, ಹಲೋ.
ಮೆನ್ಷನ್ ಮಾಡಿ ಸೇರಿಸಿ
15 ಜನ ಮಾತಾಡೋದು.
ಒಂದು ಸ್ವಲ್ಪ ಹೊತ್ತು ಮಾಡ್ತೀನಿ ಹೈಕೋರ್ಟ್ ಒಂದು ಲಾಗಿನ್ ಆಗ್ತಿದ್ದೀನಿ ಆನ್ಲೈನ್ ಆಮೇಲೆ ಮಾಡ್ತೀನಿ 2:15ಗೆ ಜಡ್ಜು ಡಿವಿಷನ್ ಬೆಂಚ್ ಹೋಗ್ತಾರೆ ಅವ್ರು ಹೋಗಕ್ ಮುಂಚೆ ಮುಗಿಸ್ಬಿಟ್ಟು ಆಮೇಲೆ ಹೋಗ್ತಾರೆ ಸರಿನಾ ಕನಕದ ನೋಡು ಕೋರ್ಟ್ ನಂಬರ್ 19 ಎರಡು ಕಾಲ ಮುಗಿತದ ನಾವು ಮುಗಿದ್ಮೇಲೆ ಸಿಗ್ತಾನೆ
Evidence 1 to 5 and 6 to. Into 6 and what is the suit for? Trial court?
Trial court has defeated the suit and the first appellate court has confirmed the same. At the time that was set up was that there was a clear partition.
Plaintiffs are entitled to 1/7 share. This has been confirmed. Now what has been done?
No, not confirmed after the first appellate court. But there is one little more share towards us.
The plaintiffs.
Not the plaintiffs. The appellants before your lordship.
It is defendants 1 to 6 and 12 to 14.
They had set up a defense, but there was a clear partition. And in terms of that, these particular properties are allotted to me. Both the trial court and the first appellate court did not review that. Now, the parties have sat together and compromised.
They are basically reiterating the prior partition.
The prior partition, and they are also not stating that they have no objection for causing a larger extent of share to the contest defendant for the appellate.
Para 9 is item number 1, para 10 is item number 2, and para 12 is item number 3.
Only 3 properties. There are only 3 properties which are subject matter of the suit. Now, in the compromise petition, not A schedule properties, there are as many as 6 branches in the family. Not out of the 6 branches in the family, not the first branch, that is the appellate 1 to 6. You also have to turn to the compromise petition that has been presented. Certain properties which are already partitioned according to us, which they did not agree. Now they have come around and said, we will give you that particular property, but give us some more out of the property.
That is D7 to D11. D? The D7 to D11.
This is for plaintiff number 9, appellate number 9, who had sought for an exemption of appearance as she is 90 years old, Your Honor.
What we of the court on the last date of hearing, that one of the parties is too old to appear.
Akayamma?
Yes, Your Honor.
She is the
appellant number 9.
Appellant number 9.
No, not that Akayamma. I am concerned with plaintiff number 1. That is first respondent, Akayamma, wife of late Dodana. Her children are Dhruva Shiva.
Yes, all are the respondents
1 to 11 are here.
Shiva, Dinakar, Sonnamma. Kantamma. Kantamma. Pillegoda. Sorry, Chaudappa. Kalavati. Surendra. Sujalata. Umesh. Harish. ನಿಮ್ಗೆಲ್ಲ ಒಪ್ಪಿಗೆ ಇದೆಯಾ? ಏನಾಗ್ತಾ ಇದೆ ಅದರಲ್ಲಿ? ಯಾವ ತರ ರಾಜಿ? ಇಲ್ಲ, ನಿಮ್ಗೆ ಏಳನೇ ಒಂದ್ ಭಾಗ ಕೊಟ್ಟಿದ್ರು ಕೋರ್ಟು. ಇವಾಗ ಅದು ಕಮ್ಮಿ ಆಗುತ್ತೆ, ಪರವಾಗಿಲ್ವಾ?
ಎಲ್ರದ್ದು ಆಧಾರ್ ಕಾರ್ಡ್.
This second appeal arises out of a suit filed for partition, in which the trial court granted 1/7 share to the plaintiffs, and which has been confirmed by the appellate court. In this appeal, compromise petition is filed, whereby the properties which are the subject matter of the suit have been allotted in the manner stated in the compromise petition. The plaintiffs were present before the court and were identified by the respective by their counsel. Admit the execution of the compromise petition. The defendants, all the defendants except the static plaintiffs and the defendants, the plaintiffs and the plaintiffs except plaintiff number 1 Akkayamma is present. It is stated that Akkayamma is aged 21 years and is unable to be present physically. Or idara alli VC alli
idare sir, idare.
So no. To video conference. Next one. The defendants 1 to 6 and defendants 12 to 14 were the appellants before the court, and they also admit the execution of the compromise petition. Similarly, defendants 7 to 11 were also present, and they also admit the execution of the compromise petition. I am satisfied that the compromise petition is lawful and the parties have entered into the compromise petition on their own free will and volition. The terms of the compromise are as under. The second appeal is accordingly allowed in terms of the compromise petition. Please to draw a decree accordingly. Sign ಮಾಡಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. Please to draw a final decree in terms of the compromise petition. ಎಲ್ಲರದ್ದು ಆಧಾರ್ ಕಾರ್ಡ್ ಇದೆ ಅಲ್ವಾ?
ಏನ್ ಕೇಳಲ್ಲ ನೋಡಿದ್ರಷ್ಟೇ ಹೋಗ್ ಮಲ್ಗೋಗು. ನನಗೆ ಸೈನ್ ಏನ್ ಬೇಕಾಗಿದೆ ಮೊದಲೇ ಕಳಿಸಿ.
Court officer. Court officer. Court officer. Court officer.
Court officer.
Court officer.
Hello, court officer. Hello, court officer.
Court officer.
ಹೇಳಿ.
ಧಾರವಾಡ ಬೆಂಚ್ ಮ್ಯಾಟರ್ಸ್ ಎಷ್ಟೊತ್ತಿಗೆ ತಗೋತಾರೆ?
ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹೋಗಿದೆ ಸರ್, ಬೆಳಗ್ಗೆನೇ ಹೇಳಿದ್ದಾರೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕಾ?
ಹೌದೌದು.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇನಾ ಸರ್?
ಹೌದು. ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲೇ ಬರ್ತಾರೆ ಸಾಹೇಬ್ರು, ಅಲ್ಲೇ ತಗೊಂತಾರೆ, ಡೇಸ್ ಅಲ್ಲೇ ಫಿಕ್ಸ್ ಮಾಡ್ತಾರೆ.
ಓಕೆ ಓಕೆ. ಧಾರವಾಡ ಬೆಂಚ್ ಇಲ್ಲ?
ಕೋರ್ಟ್ ಆಫ್ ಸರ್ ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ ಈಗ? ಇಲ್ಲ ಸರ್, ಬೆಂಚ್ ಇದೆ. ಓಕೆ, ಸೊ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್